Committee on Oversight and Government Reform will come to order pursuant to Committee Rule 5B and House Rule 11-2H4. The Chair announces that he may postpone further proceedings today on any question of approving any measure or matter or adopting an amendment on which a recorded vote or the yeas and nays are ordered. Without objection, the Chair is authorized to declare recess at any time. Our first item for consideration is the committee's authorization and oversight plan for the 115th Congress. The clerk will designate the plan.
Authorization and Oversight Plan, Committee on Oversight and Government Reform, U.S. House of Representatives, 115th Congress.
I ask unanimous consent that the plan be considered as read and open for amendment at any point. Without objection, so ordered. The plan has already been distributed and is in each member's folders. I'd now like to recognize myself for 5 minutes to describe the plan. The authorization and oversight plan for the 115th Congress describes broadly the subjects the committee intends to review, evaluate, and investigate this Congress pursuant to its legislative jurisdiction and its broad jurisdiction under House Rule 10. Certainly, the committee has a rich history of being nimble and dealing with issues as they arise. Our overall mission is to ensure the efficiency, effectiveness, and accountability of the federal government, its agencies, and we have drafted a plan that fulfills this obligation and hope that committee members will ultimately support it. I want to thank the Ranking Member Cummings for his comments and contributions. There are a number of suggestions that have been incorporated into this. Obviously, not all of the suggestions that the Democrats added to the plan have been added, nor have all of the suggestions from the Republicans been added to the plan, I would note. Again, we will maintain some flexibility. We have a rich history of dealing with situations as they arise. There are a number of carryover items from the 114th Congress that we will continue to monitor. There are things such as openness and transparency, the Freedom of Information Act that should carry on from Congress to Congress. We can talk about specific items, but let me also proactively say the Democrats have made a number of suggestions to specifically target the President of the United States. That is without precedent. That is not something that I'm aware of that has been in any of the recent oversight plans. We certainly have to and will keep a watchful eye on what the executive branch is doing. I would remind our members that in the 114th Congress, we never targeted or investigated directly President Obama. There is a careful and fine line. If there is an allegation or something that is in violation of law, it is obviously something that we would consider. But some of the fishing expeditions that have been proactively suggested, I find just that, fishing expeditions. And we have a strong duty and obligation to make sure that we oversee how the executive branch operates. To dive into somebody's personal records hoping to find something is not something that we have done. We didn't do that on Hillary Clinton. We didn't do that on Barack Obama. And we're not going to go on a fishing expedition with Mr. Trump either. But I'm happy to address that. I know there are a number of suggestions that people want to offer, and I look forward to that discussion. We'll now recognize the Ranking Member, Mr. Cummings, for his statement on the plan. Mr. Cummings, recognized for 5 minutes.
Thank you very much, Mr. Chairman. This is a critical day for our committee. Today we will vote on the committee's oversight plan for the 115th Congress. Our oversight plan sets out our priorities for the committee. It identifies the topics we will investigate and lays out how this committee will direct its resources for the next 2 years. Chairman gave us a draft of his proposal late last week, and my staff worked through the weekend to offer our input. We agreed on a few proposals, and we appreciate that. However, at the broadest level, we have simply come to an impasse. There are many issues that are essential for this committee to investigate. The issues are fundamental to our ability to fulfill our constitutional duty and uphold our oath to the American people. The problem is that the chairman simply disagrees. For example, the chairman's oversight plan omits any reference to conducting oversight of President Trump's unprecedented refusal to divest himself of his vast global business interests. We asked the chairman to include this issue in the oversight plan, but he declined. This oversight plan omits any reference to reviewing whether President Trump is violating the emoluments clause of the United States Constitution, even though his businesses continue to receive payments from foreign entities to this very day. We asked the chairman to include this, but he declined. The oversight plan omits any reference to reviewing the President's lease with GSA for his hotel here in Washington, D.C., which he owns 76% of. And even though he has violated his terms and is now clearly in breach based on the four corners of the lease, we asked the chairman to include this, but he declined. This oversight plan omits any reference to conducting basic oversight of the President's directive to build a border wall, a massive undertaking that will cost tens of billions of taxpayer dollars. We asked the chairman to look into that, but he declined. The oversight plan omits any reference to examining the tools available to defend against aggression by Russia, which just attacked our nation in an effort to influence our election. It omits any reference to Ukraine. It omits any reference to sanctions on Russia. It omits any reference to supporting NATO. We asked the chairman to include all of these items, but he declined them also. The oversight plan omits any reference to reviewing President Trump's executive orders, including his most recent executive order banning refugees broadly and travelers from 7 Muslim-majority nations. We asked the chairman to include this, but he declined. The chairman apparently has no intention of examining whether the executive order was properly vetted, how it was being implemented, or its impact on our national security, our economic security, or our civil rights. The committee will not ask any questions, despite the fact that the acting Attorney General expressed concerns about its legality, and the President fired her for saying so. The oversight plan omits any reference to ensuring that citizens of this great nation are able to freely exercise their constitutional right to vote, using the myth of voter fraud. State after state after state passed laws to suppress legitimate voters. You don't need to take my word for it. The federal courts from Wisconsin to Texas to North Carolina have uncovered the troubling effect of these laws. We asked the chairman to include this issue, but he declined. One thing is clear after barely a week and a half into this administration: President Trump plans to move at breakneck speed without the necessary vetting, debate, and thoughtful interagency consideration that prevents costly mistakes. One need look no further than the chaos that erupted at airports across the country this weekend as families were torn apart from their loved ones and agencies violated federal court orders. Despite all of these facts, the chairman has put forth an oversight plan that is simply devoid of any oversight relating directly to the President. Any investigations of President Trump appear to be simply off limits. The problem is that this plan will be judged not by what it contains, but it will be judged by what it omits. So I'm left with no choice but to turn to the other members of the committee here today, and I make the argument directly to you. I sincerely believe that you will be doing the President a service by conducting oversight of these issues early on, rather than allowing them to fester. You will help the President by putting out small fires before they become raging infernos. Democrats will offer many of these issues as amendments here today. As we ask for your support, we also ask for your vote. You do not need to be bound by the Chairman's decisions. You're independent members of Congress who each represent approximately 700,000 people. The oversight plan is our first official declaration of how our committee will conduct itself for the next 2 years as an independent check on the executive branch. The American people simply cannot afford for us to sit idly by, just waiting for things to go wrong. We must take a stand here and now for the principle that Congress will conduct vigorous oversight of the executive branch. As for your vote in favor of our amendments, not only for the benefit of the President himself, but for the benefit of our great nation. And with that, Mr. Chairman, I yield back.
Does any other member wish to speak on the plan? Gentleman from Massachusetts is recognized for 5 minutes.
Good morning. I'm sorry. Thank you. In many respects, I'd like to associate myself with the remarks of the ranking member, and just to call out the committee and remind everyone of our responsibility here. We are the single most empowered subcommittee and committee to investigate the function of government. For many years, we were the only committee that was given subpoena issuing authority, although it's been shared with several committees in previous Congresses recently. But we have an abiding responsibility, really, to make sure that the executive follows the law. And I think it's fair to say that, at least in the last 10 days, it seems like this President has been in office for about 6 months, but it's only been about 12 days. And what I would hope is that we are not seen as a committee that enables President Trump to skirt the law and to violate the Constitution. This most recent executive order, the Muslim ban, which he talked about extensively during his campaign as being just that, a Muslim ban, a ban on people who practice a certain religion from coming to this country, clearly in violation of the First Amendment, a guarantee of the freedom of religion, an expression of that religion, the right to worship the God that we choose, that has been a cornerstone of this country for forever, since its founding. His decision to issue it without vetting, without consulting with counsel, without allowing fair and open debate on this, clearly a violation of the Due Process Clause of the Fifth Amendment to ban those people who were actually citizens of this country and who had green cards in this country, and finding them banned from this country at the airport. Simply atrocious. And also the Equal Protection Clause, singling out certain religious groups that would receive favorable treatment by his administration versus others that would be less favorably treated. Clearly a violation of the Equal Protection Clause of the Constitution. So there's reason for concern here, and great concern. And I think it's our job, Republicans and Democrats, to make sure that the President abides by law. It's as simple as that. And I also think that by ignoring Mr. Trump's extensive entanglements, financial entanglements in other countries, and by giving him this blessing by by not doing our jobs, by keeping that outside of the oversight purview, I think you're inviting him to break the law. And I think we have a responsibility to remind the President what the law requires. And by excluding that as a topic for investigation here on this committee, I think you're doing him a disservice. You know, obviously, Mr. Trump is not someone who has spent a long time in government. He does not acknowledge the limitations on the office and the appearance of impropriety that his foreign financial dealings may bring upon the administration and upon this country. So I think it's our responsibility to remind him of that. And that, I think, is a special responsibility of this committee. This president, in his first 12 days, has caused great fear in the people, great anxiety in many of the people. And I think that there's, and he needs help. He needs help. If that's, you know, if you think that that is your responsibility, then I invite you to take it up. But please don't let this president discard the Constitution or dismiss it in further of his own agenda. I think that responsibility is something that we all together must abide by, regardless of our party affiliation. I yield back.
Gentleman yields back. Does any other member wish to speak? We'll recognize the gentleman from Oklahoma, Mr. Russell.
Thank you, Mr. Chairman. Mr. Chairman, just for the record, the executive order regarding immigration, nowhere does it mention the word ban. Nowhere does it mention respect to prohibitions to religion. As you know, I've been very vocal.
Would the gentleman yield?
Not just at the moment, out of respect.
Thank you, sir.
I would remind, as we try to divide on this issue, that we see many of these things in a similar and bipartisan light. I've had the privilege to travel extensively with Mr. Lynch and count him as a close friend. But in this case, the 7 countries that are listed, 6 of them are racked with civil war. Their antagonists are al-Qaeda and ISIS operatives that have disrupted and eliminated, in many cases, any type of governance or hold on those countries. The 7th country is Iran, which is the world's largest state sponsor of terrorism. So when you look at these 7 countries, I suppose it is possible through some political prism or some agenda to try to find the appropriate color that you want to shade the issue with. But the reality is 6 of the 7 countries have no sound governance, have no control over their territories or their peoples. They are racked with civil war, and they are controlled in their opposition by ISIS and al-Qaeda affiliates. It is reasonable to examine this in a bipartisan way. And we've worked very closely on these types of issues, and I think most know I'm one of the few on my side of the aisle that has been such a vocal critic on the banning of war refugees, having lived among them and having seen human suffering on a grand scale. And so I just ask that as we move forward, let's not partisan divide on these things. We need to have calmer heads that keep a sense of the issues so that we can bring those that have worked with our military here to these shores, so that we can bring maimed children and horribly burned children to our children's hospitals, and we're able to give them proper medical attention that only the United States can provide. And we can find solutions, but we will not do so if we shout over one another. And not that there's any shouting occurring in this committee today, and I think we respect each other too much for that. But we need to roll up our sleeves and work together rather than using words like ban and like Muslim and these different things that are clearly not in the executive order. I, for one, am going to ask the President to put at the fore of his escape hatches and exemption clauses in the executive order the types of groups that I just mentioned, and I believe that we'll see some action on that. But we won't get it if all we do is put things back in people's face and characterize something for what it's not. And with that, I'll yield to my good friend, Mr. Lynch, for a question.
Sure. Thank you. And look, the feeling is mutual, and we have traveled. And I would just point out that there is an obligation under this. You mentioned that six of these 7 countries are in the midst of civil war, and there is, as the gentleman does know, and I truly respect his service to this country enormously, and I say that publicly. There is a corresponding duty under the Geneva Convention that then when people are fleeing those war-torn countries, there is an obligation that we have entered into under the Geneva Convention to accept those refugees who are in fear for their lives. So the gentleman's own statement points out the incongruity between
Well, if I may-
Candidate Trump, just to be clear, did talk about banning Muslims and then conferred with Mr. Giuliani on a way to ban Muslims
Reclaiming
legally.
my time, Mr. Chairman, and thank you. I do want to point out that even though some statements might be trying to reach back, and we're going to play, this weave the game of statements. Well, I was called deplorable during the election. Now, surely somebody really didn't mean that. So I guess, what we need to look at is at the face of it. The executive order, where it is at, the 7 countries are racked by destruction and civil war with Al-Qaeda and affiliates of ISIS and others that are a threat to our nation, as we well know, and a 90-day pause for evaluation and technical means is reasonable. And with that, I yield back my time.
Gentleman yields back. Does any other member wish to speak on the plan? Gentlewoman from New York, Ms. Maloney, is recognized for 5 minutes.
Okay, I come from New York, and I can tell you that no one is more sensitive to terrorist attacks and the threat of terrorist attacks than representatives and people who live in New York. Not only did we suffer 9/11, but they have thwarted 20 other additional attempts to kill people in New York. So I think the whole country is sensitive to terrorism and wants to protect our people. And I agree very much with Mr. Russell and Mr. Lynch and Mr. Cummings. And I appreciate your sensitive comments, Mr. Russell. And it really points that this is something we should look into and clarify on, how this decision was made. How does it affect people? Is it going to affect the people that we really want to keep out of this country? And there are people we want to keep out of this country. And I wrote a letter actually to the chairman and ranking member over the weekend, seeing the chaos and fear that the order generated in New York. Fear for people who were crying. My husband was an Iraqi interpreter for the American Army. They won't let him in. I won't let my son back in. At one point, a 5-year-old boy was detained for 5 hours. He's definitely not a terrorist. And so this was creating a lot of havoc. And I think we are the Oversight Committee. It's our responsibility to look at these issues, how these questions came to and how they were resolved. And to that point, my letter asked what was the legal analysis used to justify the order, and was it vetted by career attorneys at the Justice Department, Council of Legal Counsel? I think that's an answer we all deserve an answer to. And whether the White House political staff inappropriately overruled agency lawyers, as some reports indicated. I don't know if that's true or not, but we hire people to do things. They're reporting that their advice and whatever they were saying was totally overruled. I think we should look at that and look at what type of outcome we want. So obviously, I believe that it should be part of the plan that we're voting on today. I'd like a permission to place in the record my letter that I wrote to the ranking member and chairman, and the questions that I felt needed to be answered. But more than anything,
Without objection.
this should be part of the record, and we should, as Mr. Russell said, look at these issues, and Mr. Lynch and Mr. Cummings, in a detailed way and come up with answers to them. And what federal agencies were consulted, and were they consulted, and what was their response? What guidance, if any, was developed for agencies when it was distributed, and to whom? This is a order that created massive fear and massive confusion. I had teachers and students calling me about whether or not, with their green card, as we all know is a difficult card to get, it takes years. You have to go through various levels of trust before you can get a green card, whether you can go home or go places and get back in the country. So there was a lot of confusion generated, and there still is a lot of confusion. And I feel that it's certainly something that this committee, which is charged with oversight, review, and honesty and accountability in government, to take a look at this, review it, listen to where it stands, what are the standards. No one can really figure out what the standards are. I think this is legitimate. So I respectfully join, may I just say that I respectfully join the ranking member and Mr. Lynch, and I believe in his words, Mr. Russell, in having this part of the review plan for this committee. I think it's the right thing to do.
Will the gentlewoman yield?
Absolutely.
She asked unanimous consent to have her letter entered in the record without objection. We will do that. So ordered. I would point to page 16, and let me read from the plan. Under Homeland Security, the committee will review operations management and decision-making at Homeland Security. The following two sentences later, in particular, the committee will focus on aviation, rail, port, and transit infrastructure, immigration, and border security. So to the extent that there are concerns, the question is does the plan outline in broad strokes areas that we will look at? It is clearly covered within this plan.
Reclaiming my time, it is broad strokes. And I think something that has become a concern and a confusion to the nation merits being mentioned in its own right in the plan. That's the point I'm trying to make, and I believe the point that my colleagues have tried to make.
Understood. The gentlewoman's time has expired.
Thank you, Mr. Chairman.
Does any other member wish to speak on the plan? Does any member have an amendment to the plan? And I do believe we have some.
Norton. Ms. Norton.
Gentlewoman from the District of Columbia, Ms. Norton.
Thank you very much, Mr. Chairman. As you know,
Do you have an amendment?
I have an amendment at the desk.
The clerk will designate the amendment. Do you have more than one amendment or just the one?
Just one.
Just one, okay. The clerk will designate the amendment.
Amendment to the authorization and oversight plan of the Committee on Oversight and Government Reform offered by Ms. Eleanor Holmes of the district.
Without objection, the amendment is considered as read, and the gentlewoman from the District of Columbia is recognized for 5 minutes to explain her amendment.
Thank you, Mr. Chairman. At the very least, I seek clarification of the language that I raise, which for the first time, and I've served on this committee ever since coming to Congress, contains unprecedentedly broad language in the oversight plan implying interference with the government operations of the District of Columbia. Now, I recognize that I offer this amendment because I want to make sure that the committee does not intend to intrude on the home rule rights of the District of Columbia. For example, this plan, instead of citing specific programs where there is clear congressional authority, has this broad language: review district expenditures on local programs to ensure that the expenditures are in line with the congressional mandates and federal law. Well, we're talking about local law, and we're talking about a local jurisdiction that has $220 million in surplus that is well run. I recognize the committee is in an unusual situation this Congress. It has an executive of its own party. It will be doing due diligence, perhaps in a way it has not done in the past, and certainly not the rugged due diligence it's been doing in the last 8 years. But that is no excuse for this kind of make-work language that looks like it wants to interfere with the local jurisdiction, the local government of the District of Columbia. We cannot at this point do anything but concede the Congress's constitutional authority over the affairs of the District of Columbia. Of course, Congress does not generally interfere with those affairs. There was an op-ed piece by the chairman and one Jim DeMint recently, which said, and I must correct the record on this, that Congress has the constitutional authority to regulate D.C.'s local affairs, but also the obligation to do so. Of course, it doesn't have the obligation to do so. Otherwise, the Home Rule Act of 1973, which gives that authority to the District of Columbia, would be unconstitutional. It goes on, this piece, to say that in the interest of protecting D.C. residents, imagine this, members unaccountable to the district, to district residents, and I'm quoting the language, in the interest of protecting D.C. residents, it is imperative that that Congress act. Now, this refers to the Death and Dignity Bill, which is coming up on Thursday. We understand Congress's authority to take that bill up, but this is very condescending language that no American citizens would tolerate. Nobody outside of the District of Columbia has any obligation to protect the residents of the District of Columbia, especially those who are unaccountable to the residents of the District of Columbia. Protect them from what? From their own policies, from policies that have been acted by their own local officials and mayor? Yes, this Congress may indeed decide that it disapproves of the Death with Dignity Act, and it has the authority to say so, but the language implied here is not about a specific act, but is much broader. At the very least, I would hope it would be clarified. I must say there was hyperbole in the op-ed that could only make me smile, because it said we will rage for the citizens of the District of Columbia in the Death for Dignity Act. If you want to rage for the residents of the District of Columbia, here's what to rage about. Rage about the fact that they are #1 per capita in taxes paid to support the government of the United States, but have no vote on the House floor. Rage about they are not having budget autonomy over their own local budget. The chairman has indicated that he wants to move on the government reform aspect of our OGR agenda. Then I would ask him to codify the D.C. budget referendum into federal law instead of trying to repeal it. Two prior Republican chairmen have both supported D.C. budget autonomy. It would still leave the Congress able to intervene. As one of them said, there is no drawback enlisted, lower borrowing costs, more accurate financial protections, improved operations, and of course, no shutdown of the district government. Mr. Chairman, I ask that this language be omitted, and at the very least that it be clarified so that we can be assured that the committee is operating in the traditions, the long traditions of this committee.
I thank the gentlewoman's time has expired. We'll now recognize the gentleman from North Carolina, Mr. Meadows, who's the chairman of the Subcommittee on Government Operations.
Thank you, Mr. Chairman. I rise in opposition to the gentlewoman's amendment, and I think it's critical to note that as we look at the D.C. Home Rule Act, that there are many things that are said and many things that are implied, but those go contrary to not only the Constitution, but the very intent of the Home Rule Act. As you may recall, Mr. Chairman, we had a hearing last year, and we heard from experts that actually were part of drafting the very act that the gentlewoman from the District of Columbia refers to, and it was clear that budget authority was to remain here with the overview and approval of Congress. And yet, we see constantly, and I use the word constantly intentionally, Mr. Chairman, a lack of willingness to meet halfway. The gentlewoman knows that I have in earnest offered on a number of occasions to not only work with her, but to work with the mayor and the D.C. City Council to make sure that we can address some of the legitimate concerns and yet also understand that there are legitimate concerns by members of Congress in terms of what should be and should not be taking place. You know, to allow a city council and a mayor to establish national policy is certainly not appropriate. No more than allowing the mayor of Asheville to establish national policy for these 50 great states. And so, Mr. Chairman, I rise in strong opposition, but with a renewed emphasis to the gentlewoman from the District of Columbia, and certainly for those that may be listening within the City Council and the Mayor of the District of Columbia, a willingness to work in a bipartisan way to address this in real terms. But I rise in strong opposition to the gentlewoman's amendment and encourage my colleagues to vote against it.
Will the gentleman yield?
Sure.
I too stand in opposition to this amendment. Let me read the two sentences that the amendment would strike. In addition, the committee will review district expenditures on local programs to ensure the expenditures are in line with congressional mandates and federal law. Committee will also work to strengthen Congress's oversight of the district and exercise its plenary legislative authority granted by the Constitution. Those are the lines that the gentlewoman is suggesting that we delete from the oversight plan. I find that unnecessary. We're trying to work well with the district. We have the greatest respect for the district, but it is the nation's capital. It is unique. It is different, and that's why it's designated as such in the Constitution. And we do have a duty and an obligation in this committee, the Committee of Jurisdiction, to do what the Constitution says. And that's why I think it should do. And yield back. And does the gentleman yield back?
I yield back, Mr. Chairman.
Gentleman
Thank
yields
you.
back.
Mr. Chairman.
Gentleman from, did you want to go? Or, gentleman from Virginia, Mr. Conley, is recognized for 5 minutes.
Thank you, Mr. Chairman. I just want to say, as somebody who ran a local government for 5 years and served on the local board of one of the largest local governments in the United States, 10th largest school district, I would no more welcome this committee's interference in how I ran that county government than the man in the moon. And I certainly wouldn't welcome it any more than the officials of the District of Columbia or the voters who put them in. I certainly respect the legal point the chairman makes, that the Constitution does give Congress power unspecified over the District of Columbia. But to cite that as dispositive is to also hide behind it. This is a vibrant metropolis. It is nothing like what the founders envisioned, though they had not yet experienced, the District of Columbia to be. It's not some sleepy backwater administrative center for an emerging set of colonies whose unity was fragile, carved out of the wilderness on the banks of the Potomac. That's what the Constitution granted Congress. It's evolved. And you either believe in, empowerment or you don't. And if we take the chairman's logic about we have a constitutional responsibility, why not take it all the way? In my local government, our board had a responsibility for all rezonings. So I say, if you want to assert one right, because surely this isn't just aimed at a policy you disagree with, right? Then let's take over rezonings. Let's have this committee do all the rezonings for the District of Columbia. That makes sense, because who knows? One of them we might not like. But of course, that's not really what's going on here, is it? We're playing to our base, we're cherry-picking issues, we're overturning policies adopted by the elected representatives of the people of the District of Columbia because we can, and because they make good political fodder here, elsewhere, back home. The fact that we have the power to do it begs the question of whether we should exercise that power. And I would say it is perfectly consistent with a conservative philosophy that we leave these things alone even if we disagree with them. They are the policies adopted by the elected representatives of the people of the District of Columbia. And as somebody who represents suburban Washington, close-in suburbs of Virginia, I join my colleague, Ms. Norton, in expressing deep resentment at this action and the threat of other actions. So we don't like their gun policy, so we're going to impose ours. We don't like their death with dignity policy, so we're going to impose ours. We don't like their reproductive policies for empowering women, so we're going to impose ours, because we can, begging the question of whether we should. And sometimes the better part of wisdom is restraint. It's not exercising that absolute power when we can, and people know we can, because we're going to show respect even when we disagree. That's the fundamental of a democracy. And I think we are showing enormous disrespect for the democratic process in a major metropolis in America, for all the world to see, because of our ideological down payment to our base. And in that process, we're shredding the rights of 650,000 fellow Americans who happen to live in the District of Columbia. I wish we would resist that temptation. I wish we would, in fact, on a bipartisan basis, uphold the legislative actions of the duly elected representative body of the District of Columbia, because that's the right thing to do. I yield back.
Gentleman yields back. Does any other member wish to speak on the amendment?
Mr. Chairman.
Yes, the gentleman from Maryland, Mr. Raskin, is recognized for 5 minutes.
Mr. Chairman, thank you very much. I rise in very strong favor of the gentlewoman's amendment and would like to align myself with her remarks and those of my colleague, Congressman Connolly from Virginia. The first sentence that would be struck by the amendment simply says that the committee will review district expenditures on local programs to ensure that expenditures are congruent with federal mandates. And I would invite all of our colleagues to consider how you would respond if municipalities, or take a big municipality within your district, was subjected to the same treatment. In other words, for the committee to pour over local expenditures on local programs to ensure that those expenditures are in line with federal mandates. It's simply unnecessary and it's unwarranted, and it doesn't fit within our general system of government. Undoubtedly, the local governments that everybody here represents have done something that you disagree with. But would that mean you would invite federal interference to override the local will and the sovereignty of the local government to make decisions for those people? I don't think we would do that to people in Chicago or Atlanta or Seattle or Miami or Mobile or Topeka or so on. Why would we do it to the people in the District of Columbia? Now, the gentleman makes the argument that there's a constitutional basis for this. And I think the argument proves too much. He invokes Article 1, Section 8, Clause 17, the District Clause, which says that Congress shall exercise exclusive jurisdiction over the seat of government as part of the land granted by the various states. It's also the case, however, that in Article 6, Clause 2, the Constitution establishes the supremacy clause generally for federal law over the states and localities. So if it's the case that we should be poring over everything that the local governments do to make sure that we approve of them, then we could do it for every locality in the country. And why not? So I think, in fact, we've taken the one which is perhaps the most unfair victim of federal meddling and federal interference, because it's the people in the District of Columbia who are more than 600,000 tax-paying, draftable American citizens who have no voting representation in this body, despite the valiant work of the great Congress member from the District of Columbia. She still has no vote on the floor of the House of Representatives. We're the only democratic nation on earth where the people of the capital city are disenfranchised from voting participation in their national parliament. So why pick on their local government to second-guess the judgments of the local people? This administration began with much fanfare proclaiming its belief in federalism, local control, returning power to the people, to the communities, and the language that the gentlewoman's amendment would strike goes completely in the opposite direction, and I want to simply associate myself with the remarks and the spirit of this amendment. Thank you. I yield back my time.
Gentleman yields back. Does any other member wish to speak on the amendment? The gentleman from Maryland, Mr. Cummings.
Chairman, I support the gentlelady's amendment. I want to associate myself with the comments of Mr. Connolly, Mr. Raskin, and certainly Ms. Norton. And so as Ms. Norton will have an opportunity to respond to some of the comments from Mr. Meadows, whom I have a tremendous amount of respect for, and I do believe that his intentions are honorable. I will yield now to Ms. Norton.
I thank the ranking member for yielding, and I very much appreciate the remarks of my colleagues who really have explained, I think, expansively why it is that the district must speak up when it looks like the Congress needlessly involves itself in the district's matters. Remember, this says we'll look at local expenditures to see that somehow they are in keeping with federal law. I remind the committee that the district continuously has had a balanced budget, and it has an officer that no other jurisdiction has, a CFO, so it cannot not have a balanced budget. And it is a real balanced budget, as I mentioned in my remarks. It has a $220 million surplus. One wonders what there is about how the district is run that would lead to such broad language about looking at the local expenditures to see if they are within federal law. As to Mr. Meadows, my good friend, who is the ranking member, he spoke very broadly about the Home Rule Act, of course, which is what gives the district this authority over its own local affairs. So I'm not sure what his even mentioning of the Home Rule Act does, except to lean in favor of my own remarks. He mentioned national policy. When it comes to local matters, there is no national policy unless the local, in this case, the local jurisdiction, is interfering with national policy. But for my good friend, Mr. Meadows, I take some hope from his notion, and he often says it, that he wants to meet me halfway. He knows that I have to often tease him about where is that half, where is that midpoint. I'm still looking for it, but I appreciate that he wants to meet me halfway. And I hope that that means that in practice, this language does not mean that the committee intends wholesale intervention into the affairs of the District of Columbia but essentially means to keep with the traditions of this committee and intervene when a federal issue, in fact, rises. And I thank the gentleman for using.
Would the gentlelady, or whose time is it?
Mr. Cummings' time.
Would the gentleman yield?
I yield.
I want to address, thank you for yielding, and now that this is the first time I'm speaking, coming back to the committee, I might remind everyone that during my tenure, I enjoyed working with the gentlelady from the District of Columbia and with Mr. Cummings on, in fact, strengthening home rule. I look at this specific amendment and simply want to state that the amendment before striking is not inconsistent with what I would have said was our role. And so I will not be voting for the amendment. But I want to say one thing further, which is I want to associate myself with Eleanor Holmes Norton in this sense. I think it is extremely appropriate that this committee only look at inconsistencies between federal law and federal requirements here in the federal city and not inject itself into anything which is already settled in many of our states, because I believe that the District of Columbia, as a general rule, should have the same ability to modify its activities consistent with that which is going on in the rest of the country and not inconsistent with specific federal law. And I know there's going to be some places where we can't meet halfway, but I might remind this committee, those who haven't been here as long as I've been here, that when I first came to Congress, Congress had for many years specifically prohibited the District of Columbia and its university from providing domestic partner benefits to its employees, even though as a Californian, that was currently something that the University of California did and attracted the best and the brightest based on a package that was neutral as to whether somebody was married or not, but rather simply said, we will provide this package. That was changed under Tom Davis's control of this committee, and it was changed in a way that I think we're all proud of today, that we do not interfere with the activities of the District of Columbia if those activities would in fact be allowed in our many states, and most often already is going on in our states. So although I won't be supporting this particular striking as I've read it, I do want to say that I hope that's a tenure that I revisit when I come back here, that the district should be allowed to act as the various states whenever possible. And Mr. Cummings, thank you for yielding the time.
Mr. Chairman, I yield back.
Chairman yields back. I'll now recognize myself for 5 minutes. Just a couple of notes, and I appreciate the type of dialogue that we're having here on this and the tone and tenor in which we're doing. I would point to the 111th Congress when the Democrats controlled the majority. I believe it was Chairman Towns. The management or the oversight plan at that time said regarding the District of Columbia, the committee will conduct oversight of the District of Columbia financial management system, including embezzlement in the Office of Tax and Revenue and potential material weaknesses in Medicare, Medicaid, child and family agencies. So there was a list of things that they wanted to oversee, and including financial management. And I think the Democrats all voted in favor of that at that time. I would also highlight that this is...
Could I just indicate that there were real issues that were raised in the District of Columbia at that point that deserved the oversight of this committee, and I voted for that. And I would intend to vote for similar issues if they came up in this committee again.
And reclaiming my time, that's why I don't think we should exclude that. Everything that's in this oversight plan does not dictate that there will be an individual hearing. There are different ways to conduct that oversight. Some will result in a hearing, some may be a letter, some may be a simple visit. There's several agencies there. I thought maybe there was going to be a problem, and we go and look under the hood, and we have a meeting, only to find out nothing there. And the committee never did do a hearing or do anything. We were looking at how teaching was going on overseas. For instance, in the United States military, there were some initial reports, whistleblowers, if you want to call them there, that said that there were abuses there. We didn't find anything. We didn't. This was a few years ago. We didn't find anything, so we never did do a hearing. It just We're just trying to outline this. The other thing that I would suggest is, this is not the legislative plan. This is the oversight plan. So does not preclude other legislation and things happening. In fact, I would point to the former chairman, Mr. Issa, who's on the committee here, who worked very closely with Ms. Norton on, I think it was called the Height Act, that gave more autonomy, that passed this committee, passed the body, became law in 2014, I believe, was the year. So we actually have, I think, a pretty good history here in a bipartisan way in working on these issues. And here's the other thing that I would invite, certainly the gentleman from, the two gentlemen from Maryland and the gentleman from Virginia, as well as the Ms. Norton. I really would love to explore the idea of retroceding the residential areas into Maryland, so that not only do you have a member of Congress, but you have 2 senators, a state legislature, a governor. If you want full representation, I'm very sympathetic to that, and I think there's actually a way to do that. I'm just hoping that there's a Democrat that will actually step forward and say, yeah, I'll actually join you in doing that. If you have another suggestion or idea, let me know, but if you want full representation,
Could I make an
that's
inquiry?
not in the oversight plan, that's not part of, because that would require legislation, but
Could I just make an inquiry of the chairman?
Sure.
Has the chairman ever asked anybody from the state of Maryland how they feel about that?
yes.
Would the chairman yield?
Yes, I will yield to the gentleman from Virginia.
I thank you. Yeah, that seems to be a favorite, especially of friends on your side of the aisle. But you know, there's that sort of nasty little, problem of the will of the people of the District of Columbia and the will of the people of the state of Maryland.
Well, why, reclaiming
and-
my time, why wouldn't the state of Maryland, why wouldn't the people of Maryland welcome and want? Why would they not want to do this?
Well,
We'll be able to ask them.
may I answer?
Yes,
Well,
the gentleman
the
from
chairman
Virginia.
is free to campaign in the state of Maryland to seek a referendum on that issue, I guess. But I think the easier answer is, keep our nose out of their business and give them the autonomy they deserve as any other American deserves.
Well, the gentleman,
Mr. Chairman, would the gentleman?
reclaiming my time, will yield to the gentleman from North Carolina.
I think the gentleman, I want to reiterate that seeing that there probably is not a common ground or middle-of-the-road agreement on whether Maryland or Virginia should take back the District of Columbia, I would...
Or maybe North Carolina.
I would offer once again to the gentlewoman from the District of Columbia that I will clear my calendar to find truly a middle-of-the-road agreement on how we can address some of these issues that perhaps are at odds. The gentlewoman knows that I've actually been very, I guess, acutely listening to her concerns and that of the mayor and the city council as it relates to certainly their ability to handle local matters. And the financial aspect of some of the issues are critical. And so if you want to be the liaison to work in a bipartisan way to try to find that common ground, I certainly offer that once again. I'll yield back.
Thanks. The gentleman yields back. My time has expired. Does any other member wish to speak on the amendment?
I'd wanted to respond to the gentleman just for 1 minute. If he would yield, would someone yield?
Recognize the gentleman from Missouri.
I move to strike the last word.
Gentleman's recognized for 5 minutes.
I appreciate.
I yield my time to the gentlewoman.
I thank my good friend from Missouri. I appreciate the ranking member's remarks very much. And I do want to say that he has been ranking member on the last Congress. And while he and I
I
have
believe he's been the chairman.
I mean, sorry. I'm sorry. I'm so used to being ranking member, I've lost the word chairman from my vocabulary. He has been the chairman since the last Congress. He has always worked closely with me, and we have often disagreed. But Mr. Meadows has never interfered with the operations of the District of Columbia. So I appreciate very much this discussion and the way in which he has responded and the way in which you, Mr. Chairman, have responded. And I do want to say to my good friend, I don't think the district wants to be a part of North Carolina either.
Thank the gentlewoman. Does the gentleman yield back?
Will the gentleman yield? Oh,
Sorry, who's saying? Gentleman yields back. Does any other member wish to speak on the amendment? If none, the question is now on the amendment offered by the gentlewoman from the District of Columbia. All those in favor signify by saying aye. Aye. Those opposed, no. No. In the opinion of the chair, the noes have it. The amendment is not agreed.
Request the yeas and days.
As previously, the roll call is requested. As previously announced, further proceedings on the question will be postponed. Are there further amendments?
Mr. Chairman.
The gentleman from Missouri, Mr. Clay.
Thank you, Mr. Chairman. I have an amendment at the desk and ask that it be considered as read.
Clerk will designate the amendment.
Amendment to the Authorization and Oversight Plan of the Committee on Oversight and Government Reform, offered by Mr. Clay of Missouri.
Without objection, the amendment is considered as read, and the gentleman from Missouri is recognized for 5 minutes to explain his amendment.
Mr. Chairman, this amendment is essential to ensure that the committee conducts oversight over the conflicts of interest that arise because the President continues to own a vast array of businesses. Voters in November did not vote for a laxed oversight posture by this committee or our entire legislature. On January 11, 2017, the President announced that he would defy warnings from Republican and Democratic ethics experts and refuse to do what every president has done for decades: divest himself of his corporate ownership interests, liquidate his business assets, and place them in a truly blind trust operated by an independent entity. As a result, the President continues to hold ownership in an extensive web of interconnected LLCs and limited partnerships. Neither Congress nor the American public has a full picture of these dealings because the President broke with decades-old precedent and refused to release his tax returns. In December, the ranking member and other representatives convened a bipartisan panel of ethics experts so that the American people could hear about the serious challenges these entanglements create. New York University ethics professor Stephen Gillers told Congress that it had a responsibility to obtain documents about President Trump's conflicts. He said, and I quote, "I think it is your duty. What you do with the information, you may disagree with each other, but getting the information, I think, is critical." End of quote. On November the 14th, 2016, Ranking Member Cummings wrote to the chairman and requested a review of the President's unprecedented conflicts of interest. He has not received a response. On November 28th, all Democrats on the committee wrote to the chairman requesting a similar review. We have also not received a response. Mr. Chairman, the silence is deafening. I can think of no more important priority for this committee than ensuring that every decision this President makes is not tainted by suspicion that it may have been made not out of a desire to put the American people first, but because it padded the President's pockets. This amendment sends the strong signal that this committee will maintain vigilance and exercise its constitutional duty to oversee these unprecedented conflicts. For instance, the amendment specifically addresses the President's ownership in a 46-building housing complex called Starrett City in Brooklyn, New York. The President's ownership interest is potentially valued in the tens of millions of dollars and brings him as much as $5 million in income every year. At the same time, the housing development receives substantial federal subsidies from HUD. And so, during the Senate confirmation hearing of President Trump's nominee to head up HUD, Mr. Carson refused to guarantee that the department would not take any action to personally enrich the president. This is not some hypothetical concern in a classroom. This is a concrete example that should be in every ethics textbook under the heading conflict of interest, and it should concern each and every member in this room. Sadly, the examples are as numerous as they are disturbing. Recently, the Trump Hotel CEO stated that the business wants to expand from 5 U.S. cities to 26 cities. That's a 5-fold increase in the presence of Trump hotels. Business must really be booming for the Trump brand, and it doesn't take a business degree to understand why. If we in Congress do not exercise our constitutional responsibility to conduct vigorous oversight of these unprecedented conflicts of interest, then no one will. We cannot cross our fingers and hope that the Trump organization will self-police these critical issues. And we cannot simply give the president a pass on his conflicts of interest without lifting a single finger to conduct basic oversight. I urge all my colleagues to support this amendment.
Thank the gentleman. I'll now recognize myself for 5 minutes. As our oversight plan, which is what we're debating today, clearly states, even before it goes into the individual paragraphs, I will read, quote, "The committee will retain the flexibility to investigate instances of waste, fraud, abuse, and mismanagement as they emerge and conduct oversight of other issues as appropriate." I'm sure there will be a consistent drumbeat from the Democrats to try to disparage the president's business holdings. I get it. I understand that will be what the Democrats have to harp on. I am not aware of any other previous plan ever specifically targeting a president like that. Now, granted, President Trump is different in that he is a multi-billionaire. He is required under law to provide a financial disclosure, of which he has done, I believe, twice. I'd have to check, but I believe twice. And there will be another one that he has to do in, I believe, May, as do members of Congress. I would also cite that in Section 208 of the Criminal Code, the President of the United States is exempt from the conflict of interest laws. So if there is a credible concern that there has been an abuse of power to go above and beyond the normal business dealings, then that is something that we would obviously look at and consider. For us to specifically state something as Starrett City, which is in the gentleman's amendment, I do not believe is appropriate to put in the oversight plan. I'm happy to consider any investigation that you want to suggest, and there have been a host of suggestions already. But I would again remind members that the conflict, I think the voters understood that the president had, then candidate Trump, had vast holdings. This is not breaking news. It is not breaking news that he has these vast holdings, and he is required to do a financial disclosure. Personally, just on a personal note, I was very critical of candidate Donald Trump for not releasing his tax returns. I went on national television and said I thought he should have opened up his kimono and shown the world everything in the sorry for the visual, but that's what I said. And so, and I said, but that was a suggestion, and I know it had been done previously by other candidates, but it is not required by law, and the requirement for the president is to abide by the law. and he's exempt from a lot of these things. So we will look at it, his situations as they arise, but I find that this would be inappropriate to specifically put in the oversight plan. We still maintain the flexibility and the duty and obligation where something goes above and beyond. And so,
Would the chairman yield for just a quick question?
sure,
For clarification?
Yes.
You pointed out that the president is exempt from the conflicts of interest laws. Surely the chairman did not mean, however, to suggest that he was exempt from the emoluments clause of the Constitution.
no, and
Right. Thank you.
reclaiming my time. And there is an interesting lawsuit moving forward. I don't know where that particularly would go. There is not much case history or case law on this. I think it was President Van Buren that took was offered some horses and was not allowed to take those and it ended up selling those horses. But this specific amendment, as Mr. Clay offered, I would suggest we not do. Anyway, I'm going to yield back. If they want to claim to, if somebody wants to claim. Does any other member wish to speak on the amendment?
I do, Mr. Chairman.
The gentleman from Maryland, Mr. Cummings, recognized.
I'm just going to make a general statement because this would apply to several of the amendments that are going to come up, but I want to address this one. One of the things, members, that happened the other day when the chairman and several members, and yours truly, met with Mr. Staub of the Government Ethics Organization, he talked about the concept of prevention. In other words, being ahead of something. I've heard the words used, fishing expedition, and every time I hear that, it bothers me because one of the things that, it is true that the president knew, the public knew that he had all of these entanglements, 111 minimum companies operating in 18 countries minimum. But he also knew he was running for president. There are two sides to that. He also said that he considered the presidency his #1 priority. And so, you know, he's put us in a kind of difficult position. I am glad that the chairman, and he's right, has asked about the tax returns. But we have been rope-a-doped with regard to the tax returns forever. This is probably going to be the eternal audit. That has been the excuse that we've been given. So we don't even know. It's like going down a blind alley. We don't even know what the entanglements are. The disclosure, as we all know, is because we all have to do them, would give limited information. But the tax returns would give even more. But the thing that I want us to keep in mind that this is an unprecedented situation. I don't think that this has ever happened before. And even with the hearing, the forum that we held with Mr. Eisen and Mr. Painter, ethics specialists under the Bush administration and under the Obama administration, they both said that there were things that he could do to straighten this situation out. But I sometimes get the impression that the president is not even, I mean, he will go but so far, and then he says, well, you know, this is all I'm going to do. I'm not going to divest. I'm not going to turn it over to a independent board and overseer to look over it, and refuses to do that, and then basically says, you know, impeach me. And he knows that's not going to happen. So I do believe that instances will come up where we will have to look at what is going on with the president. The emoluments clause is very, very significant. I think it would take a blind person not to understand that this is a minefield that the President is going down? And it just so happens that we have been placed on this committee to oversee government, to make sure that government runs properly. And one of the other things, we keep talking about whether it is a violation of the law. Ladies and gentlemen, we got to go to higher ground than that. It is the appearance of a conflict. That's the standard we ought to be using. And I would hope that the President would want that too. Again, the American people are tired. They want their elected officials to be honest. They don't want them to be benefiting unreasonably so from their actions. And they want to know that there's transparency. And so there's nothing wrong, I think, with us trying to lift up that standard to do some preventive things and work with this President so that he can address these issues before they become significant matters that might be harmful not only to him, but to our country. And so, again, I support the gentleman, and I want to thank the Chairman. I yield back.
Thank the gentleman. Does any other member wish to be heard on the amendment? The gentleman from Massachusetts, Mr. Lynch, is recognized for 5 minutes.
Thank you, Mr. Chairman. I also would like to speak out in support of the gentleman from Missouri's amendment. I do want to point out that this committee only has the power to investigate. We only have the power to ask questions. We don't have the power to prosecute. So really what we're doing is to get to the truth. We all know the many of us know the particulars of the post office contract that the Trump organization entered into not too far from this building, not too far from the White House. Donald Trump's company, privately held, actually acquired possession and a lease of the old post office building, now has been converted into a hotel. And part of that contract reads as follows regarding interested parties. It says that no member or delegate to Congress or elected official of the government of the United States or the government of the District of Columbia shall be admitted to any share or part of this lease. This is the lease that the Trump company entered into, or to any benefit that may arise therefrom. So there's a direct prohibition in the contract between the government, between GSA and the lessors of that hotel, that prohibit Donald Trump from any benefit from that lease. And at least as far as this oversight plan goes, we're not going to look at any of that unless I misread it. And I just think that it invites, and again, I associate myself with the remarks of Mr. Clay and Mr. Cummings, that in this case especially, I think it's a glaring example where the new president is playing it really close to the line. I actually think he's over the line. I think he's actually doing something that is prohibited, but by not looking at that and not cautioning and not having hearings and investigating, we're inviting the president to overstep that bound. You're not doing him any favors. You're not doing the country any favors. I also...
Will the gentleman yield?
In a second, yeah. Let me just finish my thought, and I'll be happy to yield. Also, there are, he's got major operations in 9 different countries. Some of those countries, none of those countries ended up on the ban list, by the way. The countries that he's doing business with, that his company's doing business with, Saudi Arabia does a lot of business. There was no ban for Saudi Arabia, no ban for any country that he's actually doing business with, which is a little surprising. But so he's got major far-flung interests, business enterprises, and I think each of them is an opportunity for a foreign government to have influence on the president. And I'm not saying that he's doing it, but it the very minimum casts an appearance of impropriety if his business interests in those countries received favorable treatment from the government, and it happens all the time. It casts aspersions on him and on the office of the presidency. And I would hope that we would stand in the way of that, we would try to protect the dignity of the office over and above what any individual occupant might do in the meantime. So about a minute and 20 seconds left, and I'm happy to yield to the chairman.
Thank you. I would point the gentleman to page 12, government contracting, as it relates to, which I do believe covers the situation with the GSA. Back in December, I initiated a process to secure the full unredacted version of the GSA contract. Staff tells me that arrived over the weekend, being the first part of the week. It's some 500-plus pages. We have not fully gone through that. But I do have an interest in this. In fact, Mr. Cummings and I have talked and discussed this several times. So any suggestion that if it says Trump, it's off limits is just wrong.
Okay, and reclaiming my time.
Yes.
And I appreciate it, and I'm happy that you're willing to look at it. I had sent a letter in about a month ago asking for a hearing on this and further investigation. I'm very pleased to find out that I've got the redacted version of the contract, so that was one of the things I wanted to take a look at. So I'm happy we got it recently over the weekend, and I'm very pleased that the chairman and the committee will be looking at that, looking at the details of that lease. And I yield back. Thank you.
Thank the gentleman. Does any other member wish to speak on the amendment by Mr. Clay from? Oh, Mr. Raskin of Maryland is recognized for 5 minutes.
Mr. Chairman, thank you very much. I rise in favor of the amendment which raises a matter of the most profound constitutional solemnity. It may or may not be true that the President is not covered by federal ethics law, but it is certainly the case that he is covered by the Constitution of the United States. He is definitely covered by Article 1, Section 9, Clause 8, the Emoluments Clause. And I think that this committee has a unique and overwhelming responsibility to enforce the Emoluments Clause. Now, what's it all about? Well, the Constitution was creating a democracy, which was a new thing on the planet Earth, against monarchs and despots and spies and governments that merged church and state. We were trying a whole new experiment. And foremost on the mind of the founders was the thought that foreign saboteurs and spies would exercise power over the President of the United States and those around him. And so they made it very clear that no person holding an office or trust under the United States government could receive any gift, any emolument, any payment of any kind whatever. For those of you who are strict constitutional textualists, please read it, of any kind whatever from a foreign king or prince or government. Now, we have a constitutional responsibility to deal with this. If we've got a constitutional responsibility to pour over local spending by the District of Columbia on its schools and its roads and its parks, certainly we've got a constitutional responsibility to zero in on the President of the United States. If we're not going to do it, who is going to do it? And it's very clear that the President of the United States may not accept an emolument without the explicit consent of the United States Congress, which is a constitutional direction to us to exercise our oversight in a meaningful way. The chairman makes the point that the people knew about this in the election. I think he said that the people knew about the vast holdings of the President of the United States during the election. Well, of course, the people didn't really know about the vast holdings of the now president because he refused to release his tax returns. He repeatedly promised he would release his tax returns, and I understand a few days ago the White House said he would not release his tax returns despite calls by people in his party, including the distinguished chairman of this committee, to deal with it, but he is not. It is also not the case that the people somehow embraced whatever they did know about the vast holdings of the president. As you know, 2.9 million more Americans voted against President Trump than voted for President Trump. So it was by the workings of the Electoral College that he became president, but we should be very clear that even a victor in the Electoral College does not have a right to violate the Constitution of the United States simply because he's won. The whole point of the Constitution and the rule of law is that people who occupy public office are not allowed to escape the strictures of the Constitution. That's what the rule of law is about. That's what distinguishes a constitutional democracy from a monarchy or a dictatorship. And if I could just say finally about the tax returns, I think that we seem to have a consensus on the committee that those tax returns should be released. And I'm glad to hear the chairman restate that, and I hope that the White House would rapidly reconsider the decision not to release the president's tax
Would my
returns.
friend yield?
Yes, I will yield.
For a question. That word emoluments, boy, that's a kind of obscure word these days in the American lexicon. What's emolument? What's an emolument, would I ask my friend from Maryland?
An emolument is any payment whatsoever. So here's what the founders were afraid of. It wasn't just gifts. There's been some suggestion by the White House that it was presents or gifts. That's not true, because the word gifts already appears in there. Emoluments is any payment of any kind whatsoever, because if you could say that the president can take any payment except for gifts, that would mean the president could actually be on the payroll of a foreign government.
And would my friend yield further, just for clarification? So, for example, the reason we might want to have hearings and support the amendment of our friend from Missouri is, in theory, a foreign government might decide to stay at a Trump hotel, let's say here in Washington, and enrich him to curry favor, and that could be construed as an emolument in some quarters. Is that correct?
The emoluments clause may be being violated a mile from where we sit today at the Trump Hotel. And I understand, at least from press reports, that a number of foreign governments have rented rooms, had parties, taken out entire floors of the Trump Hotel. And if that is money that flows into the president's pocket, that looks like a naked violation of the emoluments clause.
May I ask a question for one moment? How about a contract, a payment under a contract with a foreign government between a Trump-owned business? How does that figure into this?
I think that's
discussion?
precisely what the founders were afraid of, that the president would form a contract with a foreign government or a concern created by a foreign government. So that also would be prohibited by the emoluments clause.
Thank you.
Gentleman yields back. The gentleman's time has expired. Does any other member wish to speak on the amendment offered by Mr. Clay? Yes, the gentlewoman is recognized for 5 minutes.
Okay, so after this.
Yeah. Okay, cool. If you can, sorry, the microphone.
Yeah.
Thank you. Sorry.
I guess I speak so infrequently that I forget to turn my microphone on. Well, first of all, I just want to stand in support of this amendment and in the amendments that have been discussed thus far. And I wanted to welcome Mr. Raskin to this committee. He's going to be a very important asset. But Mr. Chairman, I wanted to say something specifically about you. I wanted to say that I thank you for having raised these issues and these concerns with candidate Donald Trump, particularly things that are related to his tax returns and things of that nature that would reveal to citizens of this country whether or not we've got any problems. Here's my issue and here's my expectation. My issue is that we may have spoken robustly about, and members of the Republican Party who are now in leadership in Congress may have spoken in such a way that would have held this accountable, this candidate accountable. He is now the elected president of the United States of America, and so I pray that we use the framework of this plan going forward in a manner that will not be afraid to advance these issues and have these discussions on behalf of the citizens of this great country. And so every time an issue is raised, an amendment is raised, you have noted a particular paragraph or sentence or combination of words in the plan that to oversee what we do. I hope that when it comes time to deal with these issues in particular, that we can expect the same kind of robust interpretation and willingness to examine. So I thank you and I yield back.
Thank the gentleman. Would the gentlewoman yield?
Yes, Mr. Chairman.
Oh, thank you, and I appreciate that. I wasn't planning on doing this, but I'll share this with the members and those watching here. President Trump visited Philadelphia when we were at our planning and strategy session. Much to my surprise, Reince Priebus, the chief of staff, said that the president would like to speak with me at the conclusion of his remarks. So I went backstage, and the president, I'd met him back in 2012 or so, but I'd never chatted or interacted with him since. The president came up, greeted me, my wife and I, and here's what he said. And I think it's worth noting. He said, you do a great job, which of course I agreed with. And then he said, listen, I understand that I'm the president. You have a job to do. You do the oversight. You don't slow down. You go after everything you want to go after. You look at anything you want to look at. I mean, if you sat there and heard what he said to me about pursuing oversight of the government and the function that we fulfill, you'd be pretty inspired. And it was inspiring to me. And for him to convey a message of don't slow down, go do your job, there's a lot to get after with the government, I think was a good message. And I just thought I'd share that with you for whatever it's
Claim my
worth.
time.
Would
Yes.
this gentlewoman from
Yes.
New Jersey yield?
Just give me 1 second to say that I'm heartened by that conversation that you had. My parents always told me actions speak louder than words, so I look for the manifestation of
Fair
that
enough. Yeah.
conversation in the business that we take care of here on this committee. And with that, I yield to my colleague, Mr. Clay.
Thank you. I want to thank the gentlewoman from New Jersey for yielding and for her words of support and balance. And just for the sake of the chairman, the next financial disclosure report from President Trump is not due until 2018. Just to clarify for you. That's the information I get, and
I thought you had to do it in May of 2017, but maybe I'm wrong. So.
okay, okay, and I was so glad to hear you share that conversation because, Mr. Chairman, I've been on this committee since 2001 under two administrations, Bush and the previous one of Obama, and as you and I know, we've been vigilant with both administrations as far as oversight duties are concerned, and I would hope that that wouldn't change under these circumstances, and so I appreciate you sharing those words from the President.
Well, would my friend yield just for a second?
I will yield.
I would just say to my friend, Mr. Clay, in light of what the chairman said, then there surely should be no objection explicitly in including calls for this kind of oversight in our plan. I yield back to my friend, Ms. Coleman.
Gentlewoman's time has expired. Does any other member wish to speak on the amendment offered by, yes, the gentlewoman from Michigan is recognized for 5 minutes.
Mr. Chairman, I am encouraged by the open dialogue that we're having, and I am in support of this amendment. And let me be very clear. Being on oversight is something that I cherish the opportunity to be the people's gatekeeper of our government, to ensure that it's functioning according to our laws, policies, our Constitution. And the only thing that I will say that's disheartening is when we start talking about rules, policies, and laws and oversight, that it's referred to this being a direct attack on the current president. The issues that we are debating are issues whoever is in the office of president, based on our laws and our rules and policies of this great country, should be enforced. It should not be an exception. When we say that our current president is a very wealthy man, we don't know how much his wealth is because he will not reveal his tax returns, but we know he's very wealthy. But there have been some clear examples that our constitutions, the founders of this country, did not want our president to be influenced by their own personal wealth or their own personal advances based on sitting in the seat of being the president. I do support this. And this is about if our president, who is Donald Trump, is in compliance and there is no conflict Let us verify that and prove that to the people by doing our job. And that's what I'm saying. If he's not in conflict, it's not something that we should just sit here and assume or guess when there are clear flags that have been demonstrated. Then if this president needs to continue his tenure without that cloud and with us doing our job, as you have stated, our president has said, then let's move forward with that. And I am still committed to recognizing that a decision was made by this country. Donald Trump is the President of the United States, but I'm also a member of Congress sent here by the people to do the work, and I serve on this committee with passion and with a commitment to do that. And I ask you to join us in support. I yield to my colleague.
Thank you very much, Congresswoman Lawrence. I just had two comments. Mr. Chairman, thank you for sharing the conversation that you had with the President. I think that it was heartening that you indicated that you would like to pursue oversight of the new administration. Where I'm coming from is I think there's a deep division in our country right now. And I think that in order to inspire trust in that part of the population that right now mistrusts what's going on in Washington, D.C., we need to shed sunlight on the President's finances. I, for one, deeply hope that the President can verify that there aren't the conflicts of interest that some people suspect. I hope that there are no emoluments, as Congressman Raskin has described. But right now, it's our responsibility and this committee's responsibility to bring that sunshine on the current situation for the sake of our country and for the sake of our union. And so thank you, Mr. Chairman, for sharing the contents of your conversation. You, I believe, have illustrated that you also believe in oversight of the administration, and I look forward to assisting this committee in my modest efforts to do whatever I can to help.
Mr. Chairman, yield. I just wanted to... Gentlewoman's time. Would you yield to Mr. Cummings, please?
Yes, I'll yield to Mr. Cummings.
Thank you very much. I just want to tell the members, the Chairman and I have been talking about the length of our hearing. We're going to, at the rate we're going, we'll be here till 9 o'clock tonight. So what we want to do is try to use our words very wisely and swiftly so that we can move through this, because there are other things happening this afternoon. And so I just want everybody to be cognizant of that, all right? Thank you.
Thank the gentleman. Gentlewoman yields back?
I yield back, sir.
Gentlewoman yields back. Does any other member wish to speak on the amendment? If none, the question is now on the amendment offered by the gentleman from Missouri. All those in favor signify by saying aye. Aye. Those opposed, no. No. The opinion of the chair, the noes have it. In a shocking upset, yes. A roll call is requested. As previously announced, the question will be postponed. Are there further amendments to the plan? The gentleman from Massachusetts, Mr. Lynch, is recognized.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will designate the amendment.
Amendment to the authorization and oversight plan of the Committee on Oversight and Government Reform offered by Mr. Lynch of Massachusetts.
Without objection, the amendment is considered as read, and the gentleman from Massachusetts is recognized for 5 minutes to explain his amendment.
Sure. Thank you, Mr. Chairman. This amendment to our oversight plan for the 115th Congress underscores that a strong and independent federal workforce is critical to our bipartisan mission of curbing waste, fraud, and abuse across the federal government. To this end, my amendment reads as follows in part. The committee will protect the key foundations of the U.S. civil service, its independence from partisan politics, and its professionalism. The committee will uphold due process and other workplace protections which insulate civil servants and whistleblowers from partisan disciplinary measures. The committee will also promote the professionalism of the civil service by ensuring fair and appropriate salaries, pensions, and benefits. To be successful, any reform of the civil service must incorporate input from federal employees, representatives, and management organizations." Close quote. So as mandated by Title V of the United States Code, every federal civil servant must take an oath of office pledging their support and defense of the United States Constitution and swearing to faithfully discharge the duties of their office. And that's important to remember in these days, especially these first dozen days of the new administration. So you have some federal employees who are firm in their belief that some measures proposed by the new president are contrary to the Constitution and laws of this country. So that requires us to protect federal employees who might be otherwise punished for their adherence to their pledge to protect the Constitution and laws and ensuring that the laws their duties are faithfully administered. As mandated, these federal employees take that pledge. In furtherance of that oath, our dedicated federal employees undertake missions that are essential to the security and safety of the American public. And that runs from caring for our wounded veterans at the VA facilities nationwide and ensuring the safety of our food, drugs, and water supplies to safeguarding our transportation system and passengers and protecting our borders. Our federal workers take this oath seriously, and that's why they have continued to faithfully perform these duties in the face of devastating budget cuts, employee furloughs, and even a 16-day government shutdown, all which have occurred over the past several years. For the same reason, our federal workforce has sacrificed nearly $160 billion towards deficit reduction in the form of 3 years of frozen pay, sequestration-related salary losses, and increased pension contributions for new hires, all while earning, in many cases, an average of 34% less than their private sector counterparts doing comparable work. These are middle-income Americans doing critical jobs in the name of public service. Regrettably, the first 2 weeks of the Trump administration have evidenced that the unwavering dedication and patriotism of our federal workforce continues to be met with efforts to undermine the federal civil service and deprive federal workers of key constitutional and workplace protections. President Trump has already signed an executive order to implement an across-the-board hiring freeze that will prevent federal agencies from hiring federal employees in critical mission areas and inevitably increase wait times for the American people and small businesses seeking vital services. As we noted in a recent letter to President Trump, signed by 107 members of the Congress, past government-wide hiring freezes enacted during both Republican and Democratic administrations have only served to reduce government efficiency and accountability and increase taxpayer costs. President Reagan and President Carter both did what President Trump is doing now. They shut down the federal hiring process. They instituted a freeze, only to find out later that they had to replace those employees with private contractors at a far greater expense. The Trump administration has also sent out gag orders to professionals working in a number of federal agencies, forbidding them from speaking to Congress or the public. This action will have a chilling effect on whistleblowers, and it impedes Congress's role, especially our role on the Government Oversight Committee, to prevent waste, fraud, and abuse. Moreover, the Trump administration team has sought the names and identities of all individuals and scientists at the Department of Energy who took part in international climate talks over the past 5 years and who participated in intra-agency climate change meetings. This is reminiscent of the tactics used during the darkest periods in our history, the McCarthy era. The committee cannot compound these attacks on federal workers through the enactment of further cuts to salaries, pensions, and benefits, the deterioration of constitutional due process, or the degradation of whistleblower and other workplace protections. These misguided proposals will only weaken our federal workforce and conceal waste, fraud, and abuse at the great expense of the American public and the taxpayer. Instead, we must make every effort to ensure that our federal civil service is able to retain and recruit the experts and support staff who make sure that the government turns the lights on every day and is open for the business of the American people at the VA, the Social Security Administration, the Food and Drug Administration, and other critical federal agencies. In closing, Mr. Chairman, this committee should be at last a bulwark against political corruption and the abuse of power by protecting the independence and professionalism of the federal service. I urge my colleagues on both sides of the aisle to support this amendment, and I yield back the balance of my time. And I thank the chairman for his indulgence.
I thank the gentleman, and I now recognize myself for 5 minutes. I appreciate the personal commitment that he has to federal workers. I know he truly believes it and puts his words into action. I believe we should not adopt the amendment offered by the gentleman from Massachusetts. While I agree with most all of it, I want to be clear. There's two parts to what we do here: oversight and government reform. So as we look at the oversight plan, I also want to make sure that you know that there is a legislation that all members can work on. In fact, it goes above and beyond our committee. Any member of the body can introduce legislation that could potentially be referred to the Committee on Oversight and Government Reform. As I've said previously, and I want to be clear, the committee does, on the legislative side, plan to engage in civil service reform, retirement reform, and try to solve many of the problems we heard about over the last, not just 2 years, but 2 years since I've been the chairman, and try to address some of these things. And my concern with the amendment that the gentleman from Massachusetts is offered is the committee will uphold. We're trying to reform some of the problems that we have seen, and so I worry that by adopting this paragraph, we would give some sense that the status quo is somehow acceptable. It's just not, from my opinion, and I believe this committee is going to work towards civil service reform in a variety of fashions, retirement reform, et cetera. So that's my concern, and with that, I'll yield back. Now recognize the gentleman, Ranking Member, Mr. Cummings.
Chairman, I support the amendment, but I want to just zero in on one part, and that's the issue of whistleblowers. I know we've got a hearing coming up on whistleblowers. I want to make sure, Mr. Chairman, that we reiterate the fact that we protect whistleblowers. I think in the climate that we're in right now, whistleblowers are very, very significant, and they're going to be coming forward. As a matter of fact, I've already seen them coming forward because you've got people who, as Mr. Lynch has kind of laid out, who've been giving their blood, sweat, and tears, for example, to EPA. And their goal has been to keep water clean and keep the air clean. And then the next thing you know, people are basically threatening the very things that they have lived for and the things that feed their souls. And so you have a climate where I think people are going to be more likely to bring up things that they are concerned about. The thing I don't want is I don't want a situation of what we heard from Mr. Staub the other day of the Office of Government Ethics when he said that when the Chief of Staff for the President told him that he needs to watch it or be careful, whatever the words were, he said that it had a chilling effect on the employees in his agency. The last thing we need is for our federal employees to have any kind of chilling effect. And so I want to make sure that whatever we do, whether this amendment is accepted or not, that we reiterate the bipartisan, very strong support that we have given to whistleblowers in the past. And I encourage whistleblowers, if they see something that they fraud, waste, or abuse, or they believe that the Congress needs to hear something, that we hear it. One of the reasons why I raised that, Mr. Chairman, is because as we looked at President Trump's some statements that he put out to federal employees, we discovered that some of these statements were unlawful. In other words, they required a provision saying that whistleblowers could be in contact with Congress, and they didn't have that statement, which is very important. I don't want whistleblowers to be confused and think that they cannot come to members of Congress. As you know, Mr. Chairman, you and I have worked in a bipartisan way, and we're still working on it to make the Secret Service better. Why? And most of our evidence came from whistleblowers. DEA, whistleblowers. Park Service, whistleblowers. We were able to do and continue to do some great things in a bipartisan way. So I just want to make sure, and I know we've got a hearing coming up, but I cannot let any opportunity go by without making that clear. And one of the things that I've noticed, a few of the whistleblowers that have been calling, they call in fear, and they're confused because they're getting one thing from the administration, but on the other hand, they know that they have these rights, and so I think there needs to be clarity with regard to that, and anything that we can do, Mr. Chairman, to make sure that's clear. And I know this is not in any way, nothing in what I'm saying is negative towards you, because you and both sides have been phenomenal with regard to protecting our whistleblowers. I just want to make sure that they are clear as to where we stand. All right?
Would my friend yield?
I yield.
Just real quickly, I'm reading the language of Mr. Lynch's amendment, and I heard the chairman's objection, which seemed to imply that adopting this might cloud or preclude our reform efforts. I think this simply enshrines some principles. We're going to protect the civil service. We're going to protect its independence from partisanship. We're going to promote its professionalism. We're going to uphold the process and protections that insulate civil servants and whistleblowers from partisan retaliation. And we're going to promote the professionalism of the civil service by ensuring fair and appropriate salaries, pensions, and benefits. I don't think there's anything in this amendment that is particularly, objectionable, controversial, nor in any way, shape, or form does it preclude possible reforms this committee might want to consider or indeed adopt. I see it as a straightforward statement of principles that's quite consistent with the values the chairman has enunciated and you just enunciated, Mr. Ranking Member, Mr. Cummings. So I urge adoption of the amendment.
Gentleman yields back. Does any other member wish to be heard on the amendment? If none, the question is now on the amendment offered by the gentleman from Massachusetts. All those in favor signify by saying aye. Aye. Those opposed, no. No. In the opinion of the chair, the noes have it. The amendment is not agreed to.
Mr. Chairman, before you...
Mr. Chairman, I want a roll call.
He asked for a roll call.
A roll call has been requested. As previously announced, further proceedings on the question will be postponed.
Mr. Chairman, procedurally, I want to ask for just the opposite. I'd ask for a roll call in light of the very productive discussion we had on how the amendment involving the District of Columbia can be interpreted, and what I take from that discussion that there was no intention for wholesale intervention or intrusion into the matters of the District of Columbia, but the kind of oversight that I think the District of Columbia expects. That is to be seen, but I don't see the need to go down for a roll call vote in light of that very productive discussion, and I withdraw my request for a roll call vote.
Thank the gentlewoman. She's asking unanimous consent to withdraw her amendment as previously requested. Any objection to that request? Hearing none, so ordered. And we thank the gentlewoman.
She's withdrawing the request for roll call.
She's what?
She's not withdrawing the amendment, just a request for roll call.
Yeah, sorry. To further clarify, counsel says that let me say it again. The gentlewoman is asking unanimous consent to withdraw the request for a roll call vote. She is not requesting the withdrawal of the amendment itself. Without objection to that, so ordered. Now recognize the gentleman from Virginia.
Thank you, Mr. Chairman. And heeding the call of the ranking member, I have an amendment at the desk, and I am going to speak remarkably briefly.
Clerk will designate the amendment. We'll see how true that is.
Amendment to the Authorization and Oversight Plan of the Committee on Oversight and Government Reform, offered by Mr. Connolly of Virginia.
Without objection, the amendment is considered as read. The gentleman from Virginia is recognized for 5 minutes.
Thank you, Mr. Chairman. This amendment directs the committee to scrutinize executive orders to ensure they don't exceed the President's authorities. My friends on the other side of the aisle objected so strenuously to the fact that President Obama was issuing executive orders because they felt that it exceeded presidential authority. This would simply add it to our work plan to make sure this president doesn't make the mistakes my friends on the other side of the aisle claimed were being made by the previous administration. I think this is a simple, common-sense amendment, and protecting the president from himself sometimes is a very important role of this committee. I think it's huge. I think you're going to love this amendment. It's very, very good. It's really going to make a big, big, big difference, and the people are going to love it. And it will help keep America great. So I yield back the balance of my time, which is 4 minutes and 11 seconds, hoping that it wins some votes.
I will now recognize gentleman yields back. I'll now recognize myself for 5 minutes. Speaker Ryan has made it clear that the committee and all other committees will perform their constitutional oversight duties. We have obviously a key duty, role, and responsibility. We have such broad jurisdiction. Other committees also have that and have to go through and need to go through a rigorous oversight as well. It is the intention of the committee to continue its oversight work just as we have, and the plan includes both, on a variety of different issues. Also wanted to just note, going back to what Mr. Cummings said previously, I do concur with the idea, the notion, the commitment that we have to whistleblowers, that they have a right to contact Congress, interact with members of Congress, and we will fight in a very bipartisan way to make sure that is consistent, that is something that they can do freely and without retribution. I would note for the members, we have a hearing tomorrow with the Inspectors General. 72 Inspectors General, 13,000 people or so on their staffs. We rely very heavily on them to go back and look through and do their job. And that's why I prioritized for our committee to have a hearing with them, and that happens tomorrow. We also tomorrow have a subcommittee hearing specifically about whistleblowers. The ranking member mentioned that, and it's something that I want to make sure that we give that we pay keen attention to.
Could I ask the chair a question?
Yes, I will yield to the gentleman.
Does this mean the chair is opposing my amendment?
So, unfortunately, I am opposing the amendment. There is a lot, most of which I agree with. I just, it says that we will specifically look at this, examine the recent, I'm trying to read from the part that I have some concerns with. I get concerned when we have such specificity on something that I don't know is necessarily true in there, and that's why I have some concerns with it. Each member is going to have to look at it for themselves, but I myself will be voting against it.
Can I just...
With that, I yield back. I've yielded back.
I heard you. Mr. Cummings, if you seek recognition, you could yield to me.
I recognize Mr. Cummings for 5 minutes.
I yield to the gentleman.
I thank the chair. I thank the ranking member. I thought the courtesy of yielding one more time might be in order, given the fact I yielded back over 4 minutes of my time. The chairman claims to be concerned about excess wording. I'd be satisfied, I would say to the chairman, with a modification of the amendment so that it read, the committee will conduct oversight of executive branch directives and executive orders to ensure that they do not exceed their legal authority and that they adhere to the requirements of the U.S. Constitution and federal law, period.
Will the gentleman Yield?
Well, I will
Mr. Cummings?
certainly,
Yes. If the gentleman will withdraw his amendment, let's see if we can't work something out between now, and inevitably, we're going to have to come back before the end of the day. If the gentleman withdraws his amendment, let me work with him in the intervening time and see if I can't find something that,
if the gentleman would yield, I'd be happy to do that and work with the chairman to try to find some common ground. I thank the chair, and I do I do withdraw the amendment.
gentleman withdraws the amendment with the intention of working together to try to find something in the next couple hours before we reconvene. Without objection, so ordered.
Mr. Chairman, I have an amendment at the desk.
The gentlewoman from Michigan is recognized for 5 minutes, is recognized.
I ask that the amendment be considered as read.
Gentlewoman has an amendment at the desk. The clerk will designate the amendment.
Amendment to the authorization and oversight plan of the Committee on Oversight and Government Reform offered by Ms. Lawrence of Michigan.
Without objection, the amendment is considered as read, and the gentlewoman from Michigan is recognized for 5 minutes to explain her amendment.
Mr. Chairman, this amendment is essential to ensure that the committee examines how the GSA is addressing President Trump's apparent breach of the lease agreement for Trump International Hotel in Washington, D.C. The lease, a copy of which Chairman and Ranking Member obtained, couldn't be clearer. It says, and I quote, "No member or delegate of Congress or elected official of the government, which the President is an elected official of the government, or the District of Columbia shall be admitted to any share or part of this lease or to any benefit that may arise therefrom." As the Deputy Commissioner of GSA explained to our staffs, this is the standard clause included in all GSA leases. It is there to prevent even the appearance that an elected official might be benefiting from doing business with the federal government. This restriction makes even more sense when applied to the President of the United States. Unlike any other elected official, the President has the power to appoint the administrator of GSA. In other words, the President, both the landlord and the tenant for the Trump International Hotel. If this is not a textbook example of a conflict of interest, I don't know what is. On November 30th of last year, the ranking members of Oversight and Government Reform and Transportation Infrastructure Committee wrote to the then head of GSA to request more information. On December 8th, GSA Deputy Commissioner of Public Building Services briefed our staffs on steps GSA would take if a breach occurred. He also confirmed that this provision applies to all elected officials regardless of when they are elected. On Friday, GSA reported that the Trump Organization has provided additional information. However, that has not been clarified, and we don't know what that means. It should be clear to all of us that the President is currently in breach of this lease with GSA, and that this demands congressional oversight. It's clear, Mr. Chairman. You have spoken during our oversight in this area on national TV and requested a copy of the lease, which made it clear, like the committee, it seemed like, that the committee was taking up the issue. But after we proposed that be included in the oversight plan, it was cut or eliminated. I'm surprised by this omission, and this amendment fixes that omission. Mr. Chairman, this committee has a responsibility to ensure GSA resolves this breach of a federal contract in a manner that is free from any external pressure, real or perceived. We also have a responsibility to ensure that our President is not in conflict of our lease, our federal government lease. Although the President appears to be in breach of contract, it's hard to imagine how a dispute could not be brought to this committee. Do we really want GSA officials to be negotiating with the children of the President of the United States over the interpretation of the lease? If GSA files suit, do we really want the federal government to be suing a company in which the President still has an ownership stake in that property. This amendment is common sense ways to address the ongoing breach and to ensure that the president avoids even the appearance. As I stated earlier, this is the President of the United States. We are Congress, and we have a responsibility to protect that office from any conflicts of interest. And to omit that from our oversight plan, to me, Mr. Chairman, is something that promotes me to ask for this amendment. I urge my colleagues to support this. And Mr. Chairman, every time a foreign government comes to town, they take pride in the fact that they're staying at the Trump Hotel, as if they're doing a favor to the president, and it's a sense of honor. We have to correct this, and I yield back my time, sir.
Gentlewoman yields back. I'll now recognize myself for 5 minutes. As I've stated previously, the committee has already initiated the process of looking at this contract. I don't think this provision is necessary. I think it's presumptuous to suggest that it was an apparent breach, and just and the way you've presented it, again, you have my commitment that we are looking at it. We've already done that. That's something we've already did. We initiated that actually in the 114th Congress, and we're already doing that and continue to do that in the 115th Congress. I find it to be unnecessary, and with that, I'll yield back.
Chairman.
Recognize the gentleman from Maryland, Mr. Cummings.
Mr. Chairman, it is necessary. We've got a situation where, you know, a lot of people say we'll cross that bridge when we come to it. We're at the bridge. Here we have, and I've talked about it, I've written about it, the day that the President was sworn in on the 20th, at that moment, there was a breach of a GSA contract. And this is not some pie-in-the-sky theory. This is no fishing expedition. This is a lease that clearly states that a person who is an elected official cannot be a part of it and cannot benefit from it. And so I think the question that we have to ask ourselves is when do we intercede? When do we get enough information to say, okay, there's a problem here? And I've done everything I know how to avoid this. But then, you know, you come to a point where you got to say, okay, we're here. One of the reasons why we need to deal with this is because I think that if we don't begin to deal with these things, and again, this is not a gotcha thing, we become, I mean, these things will go on. It just opens the door for even more of this. I'm very, very pleased that the President told you to move forward with your job. And of course, I guess that says he's saying that we as a committee should move forward in our jobs. And I think that we should do that. Whether it's a part of the plan, I just want to make sure we're clear that we are going to, once you have I had an opportunity to review the lease as I have and see that there is a clear breach, we need to be asking some questions. For example, it'd be nice to ask GSA what their position is. Do they think that there's been a breach of the lease? If there has been a breach of the lease, it would be good to know exactly how they plan to address that breach. We need to know, for example, what efforts have been made to remedy this situation. And of course, the President will at some point be appointing the head of that agency. How does that interfere with that? I mean, just a lot of issues that I think we need to try to get ahead of. And I just think that, you know, a lot of times If we don't deal with a small thing, it then grows into a big thing. And with that, I'll yield to Mr. Raskin.
Thank you very much, Mr. Chair. I just wanted to add my voice to the chorus of support for this essential provision in the amendment. You know, if a member of Congress were to hold an ownership interest, whether an exclusive or a major ownership interest, in the Trump Hotel, I think that everybody would immediately consider that a scandal for three reasons. One, the emoluments clause, because we've got foreign governments that are staying in the Trump Hotel, throwing parties at the Trump Hotel, taking out entire floors at the Trump Hotel, eating $28 hamburgers at the Trump Hotel. Second is the conflict of interest question, which has been raised. But finally, and perhaps most importantly, most immediately, we've got a direct breach of the contract which says that no official of the United States or the District of Columbia government shall be admitted to any share or part of this lease or to any benefit that may arise therefrom. It could not be clearer, again, for people who have some faith and fidelity to the text of legal language. So if a member of Congress were to do this, I think we would move immediately to deal with the problem, all the more so for the President of the United States as he embarks upon the awesome duties of his office. So I want to speak very strongly for Congresswoman Lawrence's provision, and I hope that this would be the very first matter we could put on the agenda, because if we can't figure out what's going on a mile away from where we sit today, how are we going to figure out what's going on in Russia or the Philippines with all of the various foreign business entanglements of this president? I yield the remainder of my time.
Yield back.
Gentleman yields back. Any other further discussion on the amendment? Hearing none, the question is now on the amendment offered by the gentlewoman from Michigan. All those in favor signify by saying aye.
Aye.
Those opposed, no. No. The opinion of the chair, the noes have it.
Mr. Chair, I request a
Roll
vote.
call. Roll call vote has
Roll
been
call
requested. As previously announced, further proceedings on the question will be postponed. Does any other member have an amendment? Yes, the gentlewoman from New Jersey is recognized.
Thank you, Mr. Chairman. I do have an amendment at the desk and ask that it be considered as read.
Clerk will designate the amendment.
Mr. Chairman, in the 114th Congress, in both the House and Senate.
Oh, wait, hold on.
I'm sorry.
The clerk will designate the amendment.
Amendment to the authorization and oversight plan of the Committee on Oversight and Government Reform offered by Ms. Watson Coleman of New Jersey.
Without objection, the amendment is considered as read, and the gentlewoman from New Jersey is recognized for 5 minutes to explain her amendment.
Thank you, Mr. Chairman. In the 114th Congress, in both the House and the Senate, there was significant movement on bipartisan criminal justice reform. In this committee, at Ranking Member Cummings' urging, we held 2 days of bipartisan hearings on issues surrounding the incarceration and reentry. I was pleased to see that for this 115th Congress, the committee's oversight plan includes criminal justice reform. However, there is a specific issue within criminal justice that barely saw the light of day last Congress: policing. My amendment would ensure that this does not happen again. In December 2014, Ranking Member Cummings joined Judiciary Committee Ranking Member John Conyers and Homeland Security Committee Ranking Member Benny Thompson in a letter to the chairman of their respective committees calling for hearings on the use of force by police departments. They requested an exploration of policing issues ranging from hiring to transparency to data collection to the use of military equipment to civil rights training to the relationship between the community and the police. But unfortunately, although several bills were introduced last Congress that would have reformed policing across the country, Republicans refused to move on them. In the 2 years since the ranking member sent their letters, problems with police use of force has not gone away. For example, in April 2015, Ranking Member Cummings' community in Baltimore suffered the tragic death of young Mr. Freddie Gray while he was in the custody of the police. Unfortunately, Mr. Gray's name is not alone. Terrence Crutcher in Oklahoma, Samuel DuBose in Ohio, Walter Scott in South Carolina. How many more people have to die at the hands of police across this country before we can all acknowledge that this is a problem that deserves the attention of this committee? But while the DOJ Civil Rights Division under President Obama has been a champion for police reform, Senator Jeff Sessions, President Trump's nominee for Attorney General, has different views. He suggested at his confirmation hearing that the court processes launching these reforms, quote, undermine the respect for police officers and create an impression that the entire department is not doing their work consistent with fidelity to law and fairness, close quotes, a statement which I totally disagree. I am not infuriated. I am both infuriated and I am terrified by the fact that Senator Sessions even hesitates to acknowledge the crucial importance of the consent decree process in fighting against systemic and disproportionate violations of civil rights. Meanwhile, Mr. Trump talked of a law and order approach to policing and touted zero-tolerance policies that had long been found to be unconstitutional. Since his inauguration, reports indicate that President Trump even plans to cut off funding to the Community-Oriented Policing Services Office, or COPS office, which provides support to law enforcement agencies. In these trying times, my amendment would ensure that policing issues get the full and necessary attention they have needed and will absolutely require moving forward. I strongly urge my colleagues on this committee to support this amendment, and I thank you, Mr. Chairman.
Gentlewoman yields back. I'll recognize myself for 5 minutes. Candidly, I'm a bit disappointed that the gentlewoman does not agree with the section that we did include in the oversight plan regarding criminal justice. I also sit on the Judiciary Committee. I have introduced bills and support bills on criminal justice reform. I've been applauded by President Obama for my work on this. He sent me personal notes of thanks on this. I will yield to the gentlewoman.
Pardon?
I'm happy to yield to you.
Thank you. There's no way that I do not support the section of our plan that dealing with criminal justice reform. I'm simply suggesting that we need to specify that this also will include an examination of the situations involving tragedies that happen in the custody of police. But I support that this, and my remarks actually indicated that I support the inclusion of criminal justice reform in our plan. I yield back and thank you.
Gentlewoman yields back. Again, we worked to try to come up with a bipartisan section here. I'm proud of that section, and I think it does cover generally the topics that you're looking for. I mean, the first sentence, the committee will examine the criminal justice system, including arrest and sentencing, and it goes on. The committee will explore ways that the criminal justice system can be improved so that it is targeted, effective, and efficient in its pursuit of public safety. Anyway, I'm opposed to the amendment, and I'll leave it at that. I think we've got a good section here. It is something the committee will do and be involved with in criminal justice reform. You know, I'm concerned 95% of the people who go to prison, they're coming back out. And we can do a much, much better job on both ends so that we break these cycles of dependency, we break these cycles of criminality that we, there's a lot we can do. I'm personally committed to it. I've done that in my time in Congress, and it is in our plan. And with that, I'll yield back. Any other member wish to speak on this amendment?
Mr. Chairman, I think the gentlelady was zeroing in also on the death of young men in custody. Is that right? And I'm sure we'll take a look at that too, will we not?
Like I said, generally, the gentleman will yield.
Yeah.
We are going to look at criminal justice, and there are a number of things that we need to look at, and a lot of them are interwoven. So,
All right. Thank you.
If there are no other no other members wish to be recognized on this amendment, the question is now on the amendment offered by the gentlewoman from New Jersey. All those in favor signify by saying aye. Aye. Those opposed, no. No. The opinion of the chair, the noes have it. The amendment is not agreed to. A roll call vote has been requested. As previously announced, further proceedings on the question will be postponed. Are there any other amendments? The gentlewoman from Florida is recognized.
Thank you, Mr. Chairman. I have an amendment at the desk.
The clerk will designate the amendment.
Amendment to the authorization and oversight plan of the Committee on Oversight and Government Reform offered by Ms. Demings of Florida.
Thank you, Ms.
Without objection, the amendment is considered as read, and the gentlewoman from Florida is recognized for 5 minutes to explain her amendment.
Thank you, Mr. Chairman. This amendment seeks to ensure that the committee conducts oversight of President Trump's executive order directing the Department of Security to build a wall on our southern border. The plain language of the executive order makes clear that the federal government will be on the hook for funding the construction of the wall, which has been estimated to cost up to $25 billion. The truth of the matter is that no one can tell us exactly how much it will cost taxpayers because we haven't seen reliable cost estimates. Mr. Chairman, what is clear is that building this wall is going to be one of the most significant discretionary federal outlays during the 115th Congress. Compared to other topics in the oversight plan, few can rival the scale and spending involved in this project. For that reason alone, it should be included in our oversight plan. Committee oversight is also necessary because, like the flurry of executive orders issued in the last week and a half, this order has hastily crafted and raises numerous unanswered questions, such as the method and manner of construction and maintenance, the role of contractors, and the environmental consequences. Perhaps most importantly, serious questions have been raised by both Republican and Democrats about the effectiveness of the wall in deterring or disrupting illegal border crossings. Congressman Will Hurd stated, and I quote, "Building a wall is the most expensive and least effective way to secure the border." He explained, each section of the border faces unique geographical, cultural, and technological challenges that would be best addressed with a flexible sector-by-sector approach that empowers the agents on the ground with the resources they need. Our esteemed colleague seems to know a little bit about this topic. His district includes over 800 miles of border with Mexico, reportedly more than any other member of Congress. In January 2015, Chairman Mike McCall of the Homeland Security Committee stated, and I quote, "In our conversations with outside groups, experts, and stakeholders, we learned that it would be an inefficient use of taxpayer money to complete the fence." Even Secretary Kelly acknowledged during his confirmation hearing that, and I quote, "I believe the defense of the southwest border really starts about 1,500 miles south," referring to the partnership with other countries. Yet, the order and the President's recent proclamations have sent our foreign relations with Mexico, one of our leading trading partners, into a tailspin, demanding that Mexico pay for a wall, which it appears even more likely that the American taxpayer or consumer will pay, appears to be counterproductive and may spark a trade war that will only hurt American businesses and consumers. It also seems increasingly likely that the biggest beneficiaries of the wall will be the private sector businesses that line up for billions in federal contracts. Over the weekend, the New York Times reported on a failed 2006 contract during the Bush administration that ended up costing the American taxpayer $1 billion and provided flawed technical surveillance over just 53 miles of the 2,000-mile border. My Republican colleagues in the 109th Congress, including Oversight Committee Chairman Tom Davis and Homeland Security Chairman
Pete King recognized the importance of overseeing these contracts and guarding against this type of waste. They held hearings on this contract. We should follow their example. Mr. Chairman, I understand that the President was elected in part on a campaign promise to build a wall. That doesn't excuse us from our constitutional obligation to perform oversight over substantial federal expenditures. It is critical that this committee take action now to prevent those issues from arising and becoming huge problems down the road. I urge all of my colleagues to support this amendment. I yield back.
Thank the gentlewoman, and I'll recognize myself for 5 minutes. First of all, I want to welcome you and thank you for your joining our committee. We're going to be better for it. We appreciate your service, and in law enforcement, you have a very rich history and storied career, and again, welcome you here, and thank you for your service and what you've done prior to coming to Congress.
Thank you.
So don't take it personally when we oppose your amendment. I do think that this concern about border security is covered starting on page 16 under the Homeland Security section as well as the National Security section. It is something that we have engaged in previous hearings, not specific to the cost and financing of the wall per se. As the gentlewoman knows, there is quite a bit of border that is already covered by a wall, and you are correct that Donald Trump campaigned vigorously on this, and I'm sure that it's going to happen. But that doesn't mean it's beyond oversight, and I do believe that there will be several opportunities, not just in this committee, but other committees and on the floor of the House, whether it be through appropriations or otherwise, to have a say on this. But with that said, I would oppose this amendment, but would say generally that border security, the wall, is, we believe, already covered in the sections dealing with national security and specifically Homeland Security. With that, I yield.
Mr. Chairman, may I?
Yes, I recognize.
I mean,
the gentleman.
certainly, I think we all understand on this particular committee, more so than a lot of others, that our national security is, of course, our #1 priority. But my amendment specifically deals with the costs that will be passed on to taxpayers who did not make a campaign promise. And as we focus on our spending and our deficit, which I believe is a priority, particularly of my Republican colleagues, passing on a cost of $25 billion possibly to the taxpayers is inappropriate.
Reclaiming my time, it will be interesting to see how that pans out. But like I said, I do believe this oversight is covered already within our oversight plan. Anyway, with that, I will yield back. Does any other member wish to speak on this amendment? Hearing none, the question is now on the amendment offered by the gentlewoman from Florida. All those in favor signify by saying aye.
Aye.
Those opposed, no. No. The opinion chair, the noes have it. The amendment is not agreed to.
I do ask, Mr. Chairman, for a roll call vote.
A roll call vote has been requested. As previously announced, further proceedings on the question will be postponed. The gentleman from Maryland is recognized.
Mr. Chairman, thank you very much. I've got an amendment at the desk, and I hope you will consider it read.
The clerk will designate the amendment.
Thank you very much.
Hold on.
Amendment to the authorization and oversight plan of the Committee on Oversight and Government Reform offered by Mr. Raskin of Maryland.
Without objection, the amendment is considered as read, and the gentleman from Maryland is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. This amendment states that the committee will fulfill our constitutional duty to investigate all foreign funds received by any businesses owned by the President of the United States in order to guard against violations of Article 1, Section 9, Clause 8, the Emoluments Clause. Mr. Chairman, in America, we have no kings here, and our Constitution guarantees that kings and princes and foreign governments and dictators will exercise no financial influence over the people who run the government of the United States. The Emoluments Clause prohibits the President from obtaining any payment or benefit of any kind whatever from foreign governments without the explicit consent of the United States Congress. In shaping our new government, the framers believed that this was absolutely essential to guard against foreign corruption of our political and economic institutions, which tried to establish a new form of government on earth, what a great Republican president would later call government of the people, by the people, for the people. On January 11th of this year, the president announced that he would defy the advice and the admonitions of President Bush's ethics advisor, President Obama's ethics advisor, and refuse to do what every president has done for decades, to divest himself of corporate ownership interests, liquidate his business assets, and place them in a blind trust. As a result, the president continues to maintain ownership in a vast web of businesses located abroad and to do business here at home with foreign entities. And we don't know the full extent of the president's foreign business dealings because the president, as we discussed, Mr. Chairman, will not release his tax returns, again, breaking from many decades of unbroken precedent up until now. But according to what we're able to piece together from past and limited disclosures, the president had more than 100 businesses operating in 25 countries. That's more than 100 opportunities for foreign governments to gain and to wield influence over the President of the United States. Mr. Chairman, that was the framers' worst nightmare, but it has become our living reality. And to understand how clear and how categorical the command is of the Emoluments Clause, you've got to go back to an incident that took place with Benjamin Franklin when he was representing the United States in France. And King Louis XVI gave him a snuff box as a gift. And this was the custom among the ambassadors and diplomats of the time. And there was a scandal about it and a controversy about it, but the moment that Ben Franklin returned to these shores, he went to Congress to explain that it was part of the gift-giving culture of the ambassadors, and he said, I'm happy to take it or not take it, but I submit it to Congress, and Congress approved his receipt of this snuff box. Now, I don't know how much that snuff box was worth back then. It could not have been much. Certainly not worth something like the receipts of the Trump Hotel today, or the millions or tens of millions or hundreds of millions of dollars in business deals that the Trump enterprises have all over the world today. So by what standard would we say that Ben Franklin has to come to Congress to ask for permission in order to keep a snuff box given to him by the King of France, but that Donald Trump does not have to come before Congress in order to ask our consent for his participation in business deals with foreign governments all over the world? The president has vast entanglements with Russia. The president's son has publicly stated that Russian investments in Trump businesses in the United States are, quote, or rather, quote, make up a pretty disproportionate cross-section of a lot of our assets. And we know that there are business deals that are ongoing today, both with Russia and with other countries, as well as everything taking place down at the Trump Hotel, where they have a newly created position called Director of Diplomatic Sales. And we are hearing complaints from hotels in our region, from Washington, D.C., and in Montgomery County, about the flight of foreign governments and embassies to the Trump Hotel, where they are conducting a lot of their business and having a lot of their private affairs. This does not even begin to discuss what's taking place at the Trump Tower in New York, where China and Abu Dhabi lease office space. We need to get on top of this, and that's the purpose of this amendment. Thank you, Mr. Chairman.
I thank the gentleman. Does any other member wish to be heard on the amendment? On the amendment? Recognize Mr. Cummings for 5 minutes.
Yeah, Mr. Chairman, I want to support Mr. Raskin on his amendment. As I said, I'm not going to say what I've already said before, but the Emoluments Clause is something that is clearly, I mean, if there's anything that we ought to be concerned with regard to President Trump, it's the Emoluments Clause, because the entanglements are far and wide. It's not just the institutions that he and the entities that he owns and has interest in, they're also loans. And again, we don't have the information that we need to be able to even make a good judgment as to how far, wide, and deep these interests go. And so I support the gentleman. And again, I think we need to take a different attitude of not gotcha, but prevention. I think it's nothing wrong with us trying to present to the American people an image of transparency, particularly when you look at all the people. I know Mr. Raskin was out at Dulles Airport the other night. I was at Baltimore, Washington, Thurgood Marshall Airport, along with my many colleagues. And, Mr. Chairman, people are scared. And they're also distrustful. And they feel as if their democracy is slipping away from them. And part of it is they look at what's happening with the president and feel as if he's decided that he can do almost anything. And just basically turn his back on the Constitution. I think that for the sake of all of us, for our democracy, for the morale of the American people, I think one of the best ways to address their fears, their concerns, their questions, is to have complete transparency. And I think when you have something like the Emoluments Clause, and a lot of people didn't even know that was in the Constitution, but more and more people have become familiar with it. And so I would support the gentleman. I would yield to the gentleman for his any final comments he might have.
Thank you very much. The ranking member makes an excellent point. This goes beyond just business contracts or people staying at the various hotels. It's also a question of loans from banks and businesses that are controlled by foreign governments, which again puts the President of the United States, as it would put any of us, in a totally compromised and vulnerable posture. And that was the whole purpose behind the Emoluments Clause, to make sure that foreign powers did not gain sway and influence over our officials. And I would just reiterate what the ranking member has said so eloquently. This is not a partisan question. All of us, Democrats, Republicans, Independents, Libertarians, Greens, all of us have an interest in making sure that the people who are running the government of the United States are loyal only to the people of the United States. We don't want a president, and we don't want any public official to be compromised by monetary influences coming from foreign governments and corporations controlled by foreign governments. So if we're not going to do it on this committee, who's going to do it? I think this should very much be part of our oversight plan. And I would yield back to the ranking member if he's got anything, or the chairman.
I yield back.
The question is now on the amendment offered by the gentleman from Maryland. All those in favor signify by saying aye.
Aye.
Those opposed, no. No. The opinion of the chair, the noes have it. The amendment is not agreed to.
Roll call. You want a roll call?
I would request a roll call.
Roll call has been requested as previously announced. Further proceedings on the question will be postponed. We'll now recognize the gentleman from Maryland, Mr. Cummings.
Thank you very much, Mr. Chairman. I have an amendment at the desk, and I ask that it be considered as read.
Clerk will designate the amendment.
Amendment to the authorization and oversight plan of the Committee on Oversight and Government Reform, offered by Mr. Cummings of Maryland.
Without objection, the amendment is considered as read, and the gentleman from Maryland is recognized for 5 minutes to explain the amendment.
Thank you very much, Mr. Chairman. Mr. Chairman, my amendment would ensure that this committee protects one of the most basic tenets of American democracy, the right to vote. Last week, President Trump called for an investigation into the myth of widespread voter fraud. Let me be clear. Voter fraud is essentially non-existent. The Department of Justice examined votes cast between 2002 and 2005 and found that only a microscopic fraction of the votes cast, less than 1/1,000,000th, were fraudulent. In 2014, the Washington Post investigated voter fraud and found just 31 credible instances from 2000 to 2014. That's out of more than 1 billion votes cast. Even Republican leaders in Congress agree that there's no evidence of widespread voter fraud. When asked about the President's voter fraud claims, House Speaker Paul Ryan said, and I quote, "I've seen no evidence to that effect. I've made that very, very clear," end of quote. The chairman of our committee, Congressman Chaffetz, said, and I quote, "On the voter fraud issue, that really happens at the county level. I don't see any evidence," end of quote. However, while there is bipartisan agreement that widespread voter fraud is a myth, state houses nationwide has used this myth to argue for and pass provisions that restrict access to the ballot box. In its 2013 decision of Shelby County versus Holder, the Supreme Court stripped the Voting Rights Act of crucial protections that required some states with a history of discrimination to get pre-clearance from the DOJ before changing their voting laws. Without those vital protections, voter suppression laws have run rampant. As a matter of fact, the day after the decision, there were legislators who were putting in laws basically to block people from voting. In 2016, 14 states had new restrictions in place for the first time in a presidential election. The changes included cuts to early voting and restrictions on registration. They also included ID and citizenship requirements that unduly burden young voters, women, the elderly, people with disabilities, low-income voters, and the homeless. In a decision last July about a series of new voter suppression laws in North Carolina, a federal court found, and I quote, "The new provisions target African Americans with almost surgical precision," and that's in the United States of America. It also found that the new provisions, quote, "impose cures for problems that did not exist," end of quote. Again, that's in America, the America where we spend billions trying to export democracy all over the world, telling people that they should follow us. In another ruling in Wisconsin in 2014, a federal court found that more than 300,000 registered voters in the state did not have the strict form of ID required to vote. Meanwhile, Republican leaders in Congress failed to update the voting rights formula and restore the full protection of the Voting Rights Act, even though members of Congress on both sides of the aisle introduced legislation to do so. We don't need to investigate the myth of voter fraud as President Trump has pushed for. We need to investigate the reality of voter suppression. We know that's happening. We know that there are people who were not able to vote in the last election. My amendment would ensure that this committee does the essential oversight to protect eligible voters' access to the ballot box. It is clear that we must remain vigilant in our defense of our America's most fundamental rights. It is imperative that this committee act as a firm check on voter disenfranchisement. My amendment would make sure that the committee proactively looks for ways to expand, not restrict, access to the voter box. I urge my colleagues to vote yes on the crucial amendment, and with that, I yield back.
Gentleman yields back. I now recognize myself for 5 minutes. The integrity of the United States voting system is of utmost importance, and the committee does not question the need to ensure all eligible voters are able to cast the ballot. But I also do recognize that that happens at the county and state level. It is their primary responsibility to ensure the integrity of the vote. When this came up, when President Trump had suggested that there were problems with voter fraud, I was asked if the committee was going to pursue it. Quite frankly, I just don't see the evidence of it. If evidence arises to one degree or another, perhaps we'll reconsider it, but it is not the intention of the committee to do this, particularly because I see a void in the evidence of this this allegation that the President has made. And consequently, I would also stand in opposition to the amendment as put forward. With that, I'll yield back. Any other member wish to speak on the amendment? Gentleman from Maryland, Mr. Raskin, is recognized.
Thank you very much, Mr. Chairman. I rise in favor of the distinguished ranking member's amendment here. And it is true that we have been subjected over the last week or 10 days to continued allegations of widespread voter fraud, leading to, I think the number has been suggested, 4 or 5 million illegal votes being cast. And, you know, as a kid, I was interested in magic, and one of the principal tactics of magic is sleight of hand. Hocus pocus. You pretend you're doing something with your right hand, but really you're doing something else with your left hand. And I think that the amendment directs us to what's really been going on. In the first general election in 50 years that we've had without the complete coverage of the Voting Rights Act, we saw dozens and dozens of state laws designed with surgical precision, as the court said, to disenfranchise actual American citizens, actual voters who were kept from the polls. And it was, of course, the Supreme Court's 5-4 decision in Shelby County versus Holder, which dismantled the pre-clearance provision. The ranking member often talks about the importance of prevention rather than just correction after the fact. Well, the pre-clearance provision was all about prevention. It was saying if you're going to make changes with respect to voting, you've got to pre-clear it with the United States District Court in the District of Columbia or in the district where the change is happening. That was dismantled by the Supreme Court. It opened the floodgates, and all of this disenfranchising legislation has marched through. That underscores the importance of our role as Congress in making sure that people get the right to vote, especially because we also lack that critical guardian of popular democracy, which most modern constitutions include, which is an explicit protection of the right of the people to vote. We've got a lot of amendments dealing with the right to vote, but they're anti-discrimination amendments, like the 15th Amendment, which says you can't discriminate based on race, or the 19th Amendment, you can't discriminate based on sex, or the 23rd Amendment, which gives people in D.C. the right to participate in presidential elections, or the 24th Amendment, which says you can't discriminate based on a poll tax. But nowhere do we have what most of the constitutions on earth today have. Like if you check out the new South Africa Constitution, which is a paradigm example, which is a clause that starts off the Constitution saying everybody has a constitutional right to vote at every level of government. And we still don't have that in 2017. That means that Congress has got to be the one to stand up for the rights of the people, especially when what's been described as the greatest statute in American history, the Voting Rights Act, has been dismembered by the Supreme Court of the United States. So I think that this is an essential amendment. It's not frivolous in any way. It goes right to the heart of popular democracy and government in the United States. And with that, I yield back.
Would the gentleman yield? One of the things that I think about quite often, and that is that how African American people have fought so long just for the right to vote. My mother's 90 years old, and one of the things that she talks about is how when she was a little girl that people were beaten and hung just trying, in South Carolina, just trying to get the right to vote. And Mr. Raskin, I asked her not long ago, she's a minister, and she, of course, had a stroke about a year ago. And I said, "Mother, are you afraid to die?" And I expect her, as a Pentecostal preacher, to say, "No, I'm not afraid to die." And she said, "Yes, I am afraid to die." And I said, "Why is that, Mother?" She says, "Because I don't want to die knowing that my people have lost their right to vote." It seems as if we fight this fight over and over and over again. And in a democracy, we should not have to do this. And I think that people will look back at this period, particularly with the Holder case, seeing that the Voting Rights Act was gutted, and seeing what the Supreme Court said about it in Holder, and then seeing the very next day people putting a blinder to their eyes and acting as if people are not being deprived of this right to vote. It is, I try to tell people that it is personal and it is emotional for those of us who see our relatives, our friends, and people who seem to just want to be able to control their destiny to have to go through this over and over and over again. And with that, I yield back.
Gentleman yields back. Any other members wish to be heard on this amendment? The question is now on the amendment offered by the gentleman from Maryland. All those in favor signify by saying aye. Aye. Those opposed, no. No. The opinion of the chair, the noes have it. The amendment is not agreed to. As previously announced, further proceedings on the question will be postponed. It is now the committee. Actually, the gentleman would like a roll call vote on that as well. As previously announced, further proceedings on the question will be postponed. We also had, Mr. Conley of Virginia had offered an amendment. He agreed to withdraw it to work with us on that. It's now the intention of the chair to recess, where upon reconvening, we will first hear the Conley amendment, if we come to an agreement on that, and then have the recorded votes on the amendments, and then a recorded vote, if requested, on the passage of the oversight plan. It will then be in order to continue down the roster of bills that were as part of today's markup. But the committee will now stand in recess and reconvene at the conclusion of the vote series that the Leader's Office anticipates will start around 4:45. At the conclusion of that floor vote series, we will reconvene immediately thereafter and start from there. So the committee stands in recess.
Thank you.